Good morning, everybody, and welcome to Hearing 25 in relation to proposed rezonings at Mercer and Mirimiri. Just a few introductory comments before we kick off. The first thing I'll do is just outline a little bit of the rules of engagement, as it were. Most of you will be familiar with these, but we find that it's usually helpful just to run through those things. I'll then ask the panel to introduce themselves, and then everybody else that's on the call to then introduce themselves so we know who's in the room. The first thing I want to say by way of introduction is that we've now had a number of these Zoom hearings going back to the first lockdown in March last year. And the very large majority of all the hearings that we've undertaken since that time have been by Zoom. We find it to be an exceptionally inclusive and comprehensive process, especially given that all the information that we've received has been pre-read by us. So the focus of this hearing isn't on people reading out lengthy submissions or statements of evidence. It's about summarising what it is they're wanting us to do and why, and essentially, getting to the point. It's a very limited value to the panel for people to read vast chunks of their evidence and or their legal submissions, because we have read them. So we're looking for people to spend in the order of 10 minutes speaking to a summary of what it is they're here to talk to us about. In that regard, we've received a number of the hearing highlights packages. They're also greatly appreciated, and we've read those. The way today will run is pretty standard in that the individual presenters will make their presentations to us. The panel will then ask any questions of clarification. And I really do want to stress, for those of you that are lay people on the call, and I don't think there's very many of them at the moment, but if you are talking to your colleagues who may be novices in this space, please tell them that this isn't intended to be a scary or nerve-wracking experience. We're here to listen to what they've got to tell us and simply to ask any questions if we either don't fully understand what's been said to us or we'd like a little bit more detail on something that's been said to us. So I think without further ado, we can do some introductions. When it comes to individual presenters' time, if there's anything that they wish to raise of a procedural nature, and in other words, questions about how the process will run, that would be a good time to raise them. So I think without further ado, I'll ask the panel to introduce themselves, and I guess I should start. My name is Phil Mitchell. I'm an independent hearing commissioner, and I'm the chair of the hearings panel.
Good morning, I'm Jane Sedgwick. I'm a Waikato District Councillor, but appointed as an independent commissioner.
Good morning, Janet Gibb, independent commissioner and a Waikato District Councillor.
Good morning. Good morning. I'm Diane Salton. I'm an independent commissioner, and I was a former Waikato District Councillor.
Koto Wilma, independent commissioner.
I'm Malrina. I'm Paul Koenig, deputy chair, independent commissioner and lawyer.
Thank you. So that's us. Maybe we start with the council team. And then we can just go around the table with the various submitter representatives, please.
Morning, I'm Yvonne Lagarth with the Waikato District Council, and I'm the writer of the reports.
Thank you, Ms. Lagarth.
Good morning, I'm Sandra Kelly. I'm the Senior Project Coordinator for the District Plan.
Morning all, Fitcher Bell here, District Plan Administrator and Hearings Coordinator for the Waikato District Council. Thanks.
Morena koutou, I'm Carolyn Ratt, Assistant Counsel.
Good morning, Bridget Parham, Counsel for Waikato District Council.
Good morning, everyone. Adam Jelly, Planner, Assistant Counsel.
Don't be shy, everybody. We're up to the the non-council team, if they could just briefly introduce themselves, please.
Good morning, Sarah Nairn here for TKD and Farms Limited.
Thank you, Ms. Nairn, and welcome.
Thank you.
Good morning, Lauren Semple for the Department of Corrections. I'm assisted by Rachel Murdoch.
Morning, Ms. Semple, welcome.
Thank you.
Morena everyone, Sean Grace. I'm a planner with Boffa School and here representing the Department of Corrections as well.
Thank you, Mr. Grace.
Kia ora all. Sam Gifford, Senior Environmental Advisor at Department of Corrections.
Thanks, Mr. Gifford. Welcome.
Alistair White for Reed Investment Trust.
Thanks, Mr. White. Good morning.
Good morning, everybody. I'm Josie Spillane, Chief Executive Officer at Hampton Downs and one of the few laymen on the call.
Very good.
Morena. Paula Rolfe from Paula Rolfe Consultancy, representing HD Land Limited.
Thanks, Ms. Rolfe. Thanks, Ms. Spillane. You're the one that need not be nervous.
Thank you.
Does that, I see Mr. Dawson's arrived. Mr. Dawson, can you just briefly, just so that everyone else knows who they're seeing on their screen, please?
Oh, good morning. Chris Dawson from BBO, representing Mercer Airport, which are on after morning tea. Very good.
I think that's everybody, everyone I can see at least. So thank you for that. And I think we'll just kick into it. As per the schedule that's been published, we start with the Council Section 42A report, author making a opening statement, as we call them, which is on the website and which we've read. So Ms. Lagarth, we're in your hands. Thank you.
Good morning. As you've heard, my name is Yvonne Lagarth and I'm the writer of the original Section 42A report and the rebuttal report for the zone extents in Mercer and Merry. My qualification experience is set out in that 42A report. There are 5 unrelated zoning proposals that are discussed in my reports. Each of the properties are zoned rural in the proposed plan. The properties are all in the general vicinity of Mercer and Merry, and that is what the main thing they have in common is their location. Mercer and Merry and their surrounds are not included in the regional policy statement, Future Proof 2017 or Waikato 2070 as areas where urban growth or infrastructure is planned for the future. The zone changes sought by submitters are to amend the proposed rural zone to another zone. The further submissions either support or oppose the zone change sought by the submitter. The effect of each of the zone changes sought is to provide for urbanised development on land that is located in the rural environment and identified as a rural zone in the proposed plan. On the map, I'm just going to share my screen with a couple of maps. And my PowerPoint appears to have disappeared.
I think Mr. Bell might have beaten you to it. I think he had your figures on this. There we go. Is that what?
Okay, hopefully you can see
Yes, thank you. Yep.
This is just a general overview of the area. You can see where Mercer Village is located. If you can see my highlighter,
yes,
the upper left, Merry further along, Hampton Downs, and just for context, take Kōwhata, but most of the areas are in this Mercer airfield off to the right there. Just to give you a quick run through of where they are, there is a special zone shown as number 1 here, Mercer Airport. They are seeking a new special zone together with objectives, policies and rules and obstacle limitation surface and noise insulation provisions. Number 2 on the map is Mercer Village Extension. They are seeking a change to the zone of a property near Mercer from a rural zone to the rural to the village zone to provide for low density residential development. Number 3 on the map is Mary Industrial and Business Zone. It's number 25 Island Block Road. There are 2 properties there. They are seeking a change of zone of a property from rural to industrial and business zone to support structure planned business precinct. Number 4 on the map is Hampton Downs Motorsport and Recreation Zone. They are seeking a change of zone for land that adjoins the special zone, Hampton Downs Motorsport and Recreation Zone, from rural to Hampton Downs Motorsport, Precinct E, and I'll explain the precincts later, to allow for industrial activities. And number 5 on the map is corrections. This is the location of Spring Hill Corrections Facility, and they are seeking a new special zone over Spring Hill Corrections Facility to provide for corrections purposes. I'll just give a quick overview of the planning framework for context of the zone changes. The zoning of the land must give effect to the requirements of the higher order planning instruments. The National Policy Statement for Urban Development has policies about integrating growth with infrastructure, and also the Regional Policy Statement has policies about planning for growth in specific areas and implementing the future-proof land use pattern and coordinating growth and infrastructure. Just a little more detail, the purpose of NPS urban development is for local authorities to provide sufficient development capacity in their region or district to meet expected demand for housing and business land. The rezoning proposals would make little contribution to the development capacity outcomes of that NPS. The NPS is also to assist the integration of planning decisions under the map with infrastructure and planning and funding decisions being aligned. The objectives for a zone in an urban environment are to describe the environmental outcomes intended for the zone, and the policies and rules are to be consistent with the development outcomes. The Waikato Regional Policy Statement also has a suite of provisions around urban growth. Objective 3.12 is that development of built environment occurs in an integrated and sustainable and planned manner, which enables positive environmental, social, cultural and economic outcomes. Chapter 6 of the RPS contains the policies. These reinforce the need to plan for and coordinate growth and infrastructure. The policy also provides planning mechanisms are to be used to facilitate proactive decisions about the future growth and urban development, and that the nature and timing and sequencing of new development is coordinated. In line with that, the proposed district plan, and giving effect to the regional policy statement, aims to consolidate residential and industrial growth in and around existing villages. It manages urban growth and development to achieve minimum densities in residential and village zones, and directs industrial development to strategic growth nodes. So the first on my list of 5, I'll just share the screen again. Hopefully that this is the Mercer Village extension, which is in Kaharoa Road near Mercer. What you can see is Mercer Village in the tan. It's located in the northern sector of Waikato District, and it's approximately 70 kilometres north of Hamilton. The village is a service centre with a small cluster of villages and dwellings, businesses and dwellings. The subject land is zoned rural and the proposed plan is shown in pink here. They're seeking a village zone, and what you can see here, the existing proposed village zone is shown in tan. These are power lines traversing the site, and you can see the context with the Waikato River and the state highway. Ms. Nairn and her planning evidence reduced the extent of the area sought in submissions. This is shown in blue here. There are, Ms. Nairn's planning evidence is that approximately 18 to 20 sites could be created in this 10 hectare area, when allowance is made for topography, access and the transmission lines located on the site. You can just faintly see the transmission lines here going through the site. The planning constraints for the site include a lack of planned or existing infrastructure. The site has rolling to hilly topography with geotechnical constraints, and evidence on the geotechnical issues was provided by the submitter. While appearing close to the village, the practical access is at a distance from the more urban areas of the village. So the more intensive area of the village is here. The practical access appears to be here, but without seeing final designs, it's difficult to know. So this is Kohira Road, which is how the village is accessed. While appearing close to the village, the practical access is at a distance, and high voltage power lines result in a low capacity for intensified urban development. In the proposed plan, policy 413 is to locate urban growth only where that is consistent with the future-proof strategy. In my opinion, extending the village zone to enable a more urban and residential development would undermine the implementation of that policy, and the panel may wish to consider consequential amendments if it chooses to accept the submission to change the zone for this site. The issues are that there needs to be a well-connected urban form. New development needs to be integrated into the form and character of the existing village. The site is outside an area where future growth and where infrastructure is planned, and is at a distance from the more intensively developed urban centre. The nature and scale of the development is limited by the topography of the site, high voltage power lines, lack of access to articulated infrastructure, and that comes to lot size too, because waste can be managed, provided the lot size is of a more rural scale. There are larger sites within the village zone where infill development can still occur. So that's these sites you can see between the subject site and the village. The village zone promotes a high density and more urban character than the rural zone. The permitted activity rules envisage residential development, and controlling the potential effects of the transmission line and managing the geotechnical constraints would be difficult, in my view, under that zone. The evidence has not demonstrated that the infrastructure needed to support the intensification is feasible and affordable, that subdivision into more lots would not have adverse effects on the transmission lines. My recommendation is that the submission be rejected, because the constraints on the development would not result in a character that is in keeping with the village zone. Would you like to, if you have questions, I'll possibly wait to the end.
I think carry on. I think it's probably best.
The next site, this is 25 Island Block Road, Mary Mary, shown in pink here. There are two sites, so I'll just move to the next slide, which shows you the next one. This is the next site in pink. The submission from ward demolition sought a change of zone over these two sites to industrial and business zone. No evidence was received from the submitter. Mary Mary is approximately 4K south of Mercer on the eastern side of the Waikato Expressway. It's not identified as an area for growth in the regional policy statement or Future Proof 2017 or Waikato 2070, and it's not located in any industrial strategic growth nodes. The subject land is not identified in the regional policy statement as an industrial node. Land is mainly zoned rural in the proposed plan. The properties are not located within the urban area or service business zone of Mary Mary Village, which you can see to the south. There is some articulated infrastructure within Mary Mary for the business in that village. There are a number of planning constraints. The subject properties are near the Waikato River and the Whangamarino River and wetland. Portions of the land are identified on the planning map as being significant natural areas, and you can see these in the pink and the green. The route of the national grid passes through the site, and these are the lines you can see here. Information provided as a result of a consent application indicates the land is flood prone, although it's not identified in the natural hazard maps for the proposed plan. The potential effects of traffic generation on State Highway 1 have not been assessed. I've concluded that a business or industrial zone enables the type of activities that may be a concern in that location. All industrial zone activities are permitted on an industrial site, and a wide range of activities are permitted in a business zone with no conditions imposed. A change to a business and industrial zone would mean council would have limited ability to manage potential adverse effects on the national grid and surrounding environment. My recommendation is that the submission be rejected because of proximity to the Waikato River and wetlands and the lack of infrastructure, particularly trade waste servicing. The next site is Hampton Downs. Now, it's adjacent to the area zoned in the proposed plan. So if you can see Mary to the top of the screen, and a circle at the bottom of the screen on the right, and right down a tiny bit of pink, that is the property where the zone change is sought. And this is a close-up of it, and you can see precinct E, which is where the industrial activities associated with the Hampton Downs Motorsport Park is. This is precinct A is mainly used for car parking at present. The submission made by Reed Investment Trust is to change the rural zone of the property across the road from Hampton Downs Motorsport Park to Hampton Downs Motorsport Park and Recreation Zone Precinct E. These precincts arose out of a resource consent and reflect existing use on the site. Precinct E provides for industrial activities associated with the motorsport park. The land is near the park, which is a special zone in the proposed plan and is 57 kilometres north of Hamilton. The objective and policies that apply to that special zone include they recognise existing land use and use a precinct-based approach to enable ongoing operation and development of the Hampton Downs Motorsport Park. The submission and evidence from the operators of Hampton Downs Motorsport Park opposes the extension of the special zone to incorporate the property owned by Reed Investments. The subject land is not identified as an industrial node in the Waikato Regional Policy Statement. Although the subject site is reasonably flat, it's a small site, and the ease and affordability of providing water and wastewater, especially for any wet industry, would need to be demonstrated. The issues I've identified are that a special zone provides for a specific land use. The land use in the special zone needs to be consistent with the purpose of the special zone and industrial land use associated with the motorsport park. The land use in the special zone should meet the criteria in the national planning standards, which are that land use activities or outcomes are significant to the district, region or country, are impractical to be managed through another zone or a combination of spatial layers. There needs to be adequate access to the regional road network and to water and wastewater that is feasible and affordable. My recommendation is that the submission to change the zone to Hampton Downs Motorsport Park be rejected because the industrial activity is not directly linked to the motorsport park use. The nature and scale of the industrial activity as described in the planning evidence would fail to meet the criteria for the special zone in the national planning standards. And industrial activities will not be enabled by the industrial zone where it's not supported, should not be enabled where it's not supported by suitable infrastructure. The next site is Mercer Airport. This is just for context, so this is Mercer Airfield. You can see marked in pink, and Mary to the south. This is an outline of the area used by Mercer Airport currently. And Mercer Airport is located in a rural environment south of Bukakino, approximately 70 kilometres north of Hamilton. Mercer backpackers are also located on the airfield, at the area, not on the airfield. The airfield currently operates under a resource consent. The submission made by Mercer Airport is to include a special zone in the district plan to recognise the activities of Mercer Airport and to allow growth by rezoning the land owned and occupied and leased by the airport from rural zone to Mercer Airport zone, to include objectives, policies and rules to provide for the airport operations and a number of non-airport related activities, to include an air noise boundary and outer control noise boundary together with rules regarding noise insulation, to include an obstacle limitation surface for Mercer Airport to provide safety for aircraft, which involves height controls for building structures and trees, and to increase the permitted vehicle movements. The evidence lodged on behalf of Mercer Airport includes information about operational functions of the airfield, amended objectives and policies and rules for the special zone being sought. The provisions sought by the submitter enable both aircraft-related and non-aircraft-related activities as permitted activities. The issues I've identified are that the air noise and obstacle limitation surface rules impose regulations on the neighbouring property owners. The special zone as drafted by the submitter allows permitted activities that have potential adverse effects on the rural environment. There have been no consultation with the community except through the proposed plan submissions. While the national planning standards enable council to include a special zone for an airport, including that such a zone is not mandatory, I have recommended that the rural zone is not changed to a special zone. If the panel is satisfied that an obstacle limitation surface and noise insulation measures are necessary and the cost to the community can be justified, these could be included in the plan without a special zone. There were some additional submissions added in my rebuttal. They were left out in error, and they include effects on surrounding transport infrastructure and rezoning have not been addressed, and that high-class soils, hazards, landscapes and Indigenous biodiversity must be taken into consideration. There is a procedural issue for the panel to consider. The council received 2 letters from several landowners who identify themselves as neighbours. The letters were received after submissions had closed and after evidence of submitters had been lodged. The panel have received previous legal advice about the requirements in RMA 76.3 that in making a rule, the panel is to have regard to the effects on the environment, and that includes the neighbours. In considering the provisions sought by the submitter for a special zone, the panel will need to evaluate the change against Section 32 matters. These include assessing the benefits and costs of the environmental, economic, social and cultural effects that are anticipated from the implementation of those provisions sought by the submitter, and to assess the risk of acting or not acting if there is uncertain or insufficient information about the subject matter of the provisions. And I asked the panel to consider whether the information provided in the letters from the neighbours about the effects on the neighbouring environment might assist with consideration of a special zone. The next site is Spring Hill Corrections Facility. The grey area is Hampton Downs Motorsport Park, and the pink is the area occupied by the corrections facility. Spring Hill Corrections Facility is located on a 215 hectare site near Merry and is near the Hampton Downs Motorsport Park. The land is the subject of a notice of requirement for a designation for corrections activities. The special zone includes objectives, policies and rules that provide for activities undertaken for corrections purposes. These are in the planning evidence rather than the submission or further submission. The national planning standards enable the council to include a special zone corrections in the district plan, but including such a zone is not mandatory. Where a zone is used, the plan use must be consistent with the description of that zone. The further submission made by the department sought a new special zone corrections. I consider that it's arguable whether there's scope in the submission, further submission, to include the special zone corrections in the plan. The National Planning Standard has a framework and describes what's in the zone, but it doesn't include the specific provisions that may apply. Those are still subject to a Schedule 1 process in the Section 32 test. The details of the plan provisions were in the plan, only in the planning evidence. Further submissions could not be made. Where designation is in place, the district plan has limited application. The purpose of an underlying zone is to manage the activities and not provided for by the designation. I think this is the point of difference between my reading of how a designation underlying zone applies and the corrections planner. The permitted activities sought by the submitter allow residential activities that are of a greater nature and scale and will be expected in the rural environment, and this has potential adverse effects on rural amenity and character. I've recommended that the proposed rural zone is not changed to a special zone corrections, because I consider there's a need for a rural zone to manage activities in the environment that are not provided for by the designation, that there should be an opportunity for people to make a submission on the proposed activities and provisions that are sought. The potential effects of the permitted activities sought are of a scale that should be the subject of a consent application and an assessment of effects on the environment. There is a procedural issue for the panel to consider. The special zone sought by the Department of Corrections was introduced in their further submission on their own original submission. This goes beyond the original submission point, and the details sought were only revealed in the planning evidence of Mr. Grace, so there's no opportunity for people to make further submissions on the special zone and provisions sought. And the department has provided legal submissions on this issue. And those are the 5 sites. Happy to take any questions if you have questions.
Thank you very much, Ms. Lagarde. We may well have some questions. Let's see. Could we start with you, please, Ms. Sedgwick?
Thank you. I have a question relating to the rezoning in Meremere. In your report, you talk about the effects on State Highway 1 haven't been assessed. Are you aware that Waka Kotahi has signalled its intention to close off the Island Block Road access to emerging traffic, so that heavy vehicles would need to traverse through the Meremere village to exit if going north? So it's a LILO, in left in, left out option. I didn't see that in your report. Are you aware of that?
No, I'm not aware of that. And things like transport access could be considered through a consent if that went forward in the future. If the owner decided to proceed with business activities.
Although your report does talk, I think in your report talks specifically about heavy traffic not going through residential areas. So I just make that point by clarification.
Thank you. Ms. Gibb?
No, nothing from me. Thanks, Mr. Lagarde.
Mr. Marg?
Yeah, look, thank you, Mr. Lagarde. Just a couple of points of clarity, particularly in the last one around Spring Hill and the reference that you made about the understanding between yourself and the planner around the designation. Can you just add a little bit more to that? I didn't quite get what you were saying.
So the planner has sought a special zone to provide for corrections facilities. And my view is that the purpose of an underlying zone where a designation is in place is that it provides for activities that are not included in the designation. So as an example, to use a Defence Force example, if the area which is designated for defence purposes had a cafe or a museum, then that would require resource consent, and that would be assessed against the underlying zone. So if where an underlying zone and the designation deal with corrections, it creates a gap in the plan, in my view.
Okay, no, thank you for that. No further question.
Thank you. Mr. Fulton?
Yes, just one. Are you able to tell me the other correction facilities, and I know there's a lot of them in New Zealand, I'm just thinking of the Wanganui one, which is in a rural area. Do they have a special zone or are they just dealt with in the rural? Or are you able to give me any comparisons to any others that are dealt with separately?
So the special zone is a new tool that came in through the National Planning Standard, and my understanding is that none are in place at the moment. And an important factor with the prisons also is that they are of quite different sizes and have different activities going on. So, for example, the Auckland aren't surrounded by rural land, but other facilities are. So the
Thank you.
type of provisions that might be imposed could be very different.
Okay, thank you. I think that's fair enough. All I wanted to know. Thank you.
Thank you. Mr. Cooney?
Yes, on the airport matter, you seem to have placed quite a bit of weight on the correspondence that was received from the neighbourhood or from the properties around the airport. Is that a fair summary of how you approached that?
No, I had completed drafting the Section 42 report before those letters were received, and I believe it would have been on the website as well. So yes, they came afterwards, but what they did do is identify some issues that I hadn't already identified.
Okay. So what is the difference between what the amended consent allows the airport to undertake, the activities that it can undertake under the consent, and what they're seeking under the special zone? So you've got an OLS, is that right? That's
right.
That's a point of difference.
Yes. So the obstacle limitation surface places height controls and development controls on living room properties.
Yeah, I know that.
And also noise insulation.
Yeah. So that's two. That's two. What else?
And also there are, the resource consent doesn't provide for non-aircraft related activities such as the backpackers and temporary events.
I thought the consent did allow for backpackers.
Oh, I will check.
Anyhow, okay, and that's three. I think I've counted. What else? What else did you say?
I will just open up the evidence. I've got it in front of me. So the list of permitted activities sought and that provided, there's a statement about storage and warehousing, which may or may not be related, but because it's a permitted activity, the purpose of it couldn't be assessed. Non-aviation temporary events, club rooms, cafes, and accommodation.
Yeah. So backpackers are allowed, aren't
they? I'm looking at the permitted activity sought. Yeah.
Oh no, the consent. Have you checked the consent? I haven't got it in front of me at the moment. I looked at it the other day.
I just flick down. The backpackers would have an existing use currently, but the additional accommodation above the hangars is different.
Anyhow, we'll get that sorted out. And you've got additional traffic movements, I think, that what the consent approves.
Yes, that was take that from the submission point.
And you've got seeking to allow for jet aircraft.
So currently the resource consent allows for a number of aircraft movements over a period and has limitations on noise levels. It's likely that jet aircraft, which are mentioned in the submission, wouldn't fit in that noise profile.
No, but they're now seeking that, aren't they? That's what they're seeking.
Yes, and I've just located the backpackers accommodation may cater for a maximum of 30 people in the resource consent.
All right, okay. So what the difference between what's currently operating under the consent and what they're now seeking is, in your opinion, the impacts of that? You've said they warrant the submission to be rejected. Is that's
yes,
the number?
And that's, so as a permitted activity, for example, helicopters and light jet aircraft are permitted, and additional accommodation above the hangars, which is not the case now. And I think those types of activities could have the types of effects that are unexpected in the rural environment, and that warrants an assessment of the scale of effects and perhaps conditions on a consent to control those effects.
And you've undertaken that assessment?
No.
Okay. All right.
As a permitted activity, council would have no role or ability to undertake such an assessment.
Okay. All right. Okay. Just on the corrections special zone, you seem to be taking a sort of a strict approach on that matter. It's almost a jurisdictional issue, isn't it?
Well, my concern is that there could be created a gap in the plan if you have a special zone and a designation, which both provide for the same activities, but a non-corrections related activity has no provisions in the plan. If there's a special zone, what would it be attested against?
Okay. We've heard from corrections as to the type of activities that are undertaken there, and what they're now seeking. There's not a great difference, is there? You know, in terms of the activities they want to pursue here, than what they can do under the designation.
That's right.
So your concern is that they might want to do something that is not really consistent with the purpose for which the designation is, or the activities that are allowed under the designation, and therefore you should reject their submission and keep to the underlying zone.
Perhaps an extreme example might help. In the unlikely event that corrections consolidated on its other sites and lifted the designation, if there was a corrections special zone, that would be what's left. So my recommendation is that the designation provides for the corrections activities, but in the event that that designation was lifted, the rural zone would apply.
But you've got a huge prison here with its associated activities. That's sort of almost getting to an sort of an implausible situation, isn't it?
It could be, but the area occupied by the prison is a small area in the context of the 200 hectare site. And so what happens on the rest of the site, and Mr. Grace can probably assist you with this, but it appears to be rural activities on the remainder of the site.
Your sort of worry is that one day they might think, oh, there's a bit of spare space here, we'll come along and subdivide it and sell it off.
Or in order to support, other activities may occur if they, for example, leased it in order to maintain that rural land, lease it to a farmer, then farming operations would require resource consent. whereas under the rural zone it wouldn't.
But that's their problem, isn't it?
Yes, although my concern is about the plan and that a gap is not created as a result of the special zone.
All right, thank you.
Thanks, Mr. Kearney. I've got just a couple of questions, and I think the first one's probably addressed to Ms. Parham, perhaps. And I wonder, Ms. Parham, have you had a chance to read Mr. Dawson's legal submissions on behalf of Mercer Airport?
Yes, I have, Mr. Chairman.
He has raised a number of matters and sort of definitional type matters, I suppose you might say. You know, one's in terms of what the environment is and what we are allowed to assess and not assess in relation to that definition. And he also addresses relationships between the proposal and what landowners have had to say. Do you have any comments that might assist us in that regard, please?
Yes, Mr. Chairman, this issue actually arose in a couple of the previous hearings, in particular the hearing for Māori sites and areas of significance. And the panel may recall that following that hearing, I did provide some legal submissions to the panel, which are available on the website. And I see that Mr. Dawson has cited those legal submissions in his submissions for Neil Russell Limited. So that exact issue arises here. So whether we've got a situation where landowners have found themselves impacted by a submission, but they didn't lodge a further submission in opposition to that submission. So the issue is, to what extent can their concerns or interests be taken into account? Mr. Dawson and I are not, well, in my view, we're not significantly far apart. He agrees with me that the panel is obliged to consider the effects of the new airport zone on the environment. And he also agrees that that includes any environmental effects on the neighbouring properties. Where Mr. Dawson and I depart is that he says any environmental effects on the neighbouring properties is not the same as taking into account the concerns and interests of the individual landowners, or what those individual landowners' views may or may not be. So we've essentially, he takes a narrow issue of the definition of environment, whereas I take a wider meaning of the definition of environment, because under the RMA, it is a broad definition. It is not limited to the physical land itself, but it includes people, communities, amenity values, etc. So I don't think it's possible to distinguish between the effects on the neighbouring properties and the effects on the landowners of those properties. And if I take an example that Mr. Cooney that Ms. Lagarth has just discussed, one of the differences between the operations under the resource consent and the operations under the proposed new airport zone is the ability to fly jet craft. Now, a jet flying over the physical land is probably not going to have a physical and environmental impact on the land itself. There might possibly be some ground vibrations. However, a jet flying, particularly at night, and I understand that the new provisions do seek to extend the hours of operation, a jet flying at night is clearly going to have some significant sleep disturbance on the people occupying the neighbouring land. So I don't think you can separate the effects on the property from the effects of the occupiers of that property. So I take a wider, if you like, more realistic or real world view of the definition of environment, and Mr. Dawson takes a narrower view. I have had a look to see whether there is any case law on this particular issue. And well, certainly there's case law which talks about the definition of environment being wider and including landowners, not just the environment, but in terms of the wider issue of the interest of landowners who are not submitted, I haven't found any case on that, and I note that Mr. Dawson's Mr. Dawson's legal submissions doesn't refer to any case law either.
All right, no, that's very helpful. Thank you. Are there any questions from the panel arising in relation to that?
Yes, Ms. Parham, doesn't it? I know there's a difference between you and Mr. Dawson. Doesn't it come down from our position? Doesn't it become just a question of weight we give to the letters and correspondence received from the neighbours? It's not primary evidence, and by that I mean it's not evidence that we hear directly from a submitter. We can ask questions of those concerns, etc. So it's more or less secondary evidence, and so it's a question of weight. What do you say?
I absolutely agree with you, Mr. Cooney. The landowners who have written to council, they don't have status as submitters. They can't provide evidence. The most you can do, as Section 76(3) directs, is to have regard to the effects on those landowners, but have regard to the court has confirmed means, turn your mind to it, give it genuine attention, but at the end of the day, you don't have to accept the contents of those letters. So it does come down to what weight, if any, the panel gives those letters, and that weight is at the panel's discretion.
Mm-hmm.
So we really take a broad objective view of these letters and things. Would you say that?
Yes, and I would, even in the absence of receiving the letters from the landowners you've received it from, even without those letters, the 42A report officer, in my view, would be considering the effects on the environment anyway.
Mm.
Along with all the other tests that she has to apply. So it's not that, it's a balancing. It's not that one takes priority over all the other tests.
The fact that the neighbours never made a submission, we can't read too much into that as to the reasons why, etc. We can't, for example, say, oh, they didn't have any concerns, and therefore, there's no problem there. We can't sort of jump to that conclusion simply because someone didn't file a submission.
I think it would be speculating to come up with reasons why a landowner may or may not have submitted. We just don't know. Councils follow the Schedule 1 process, and there's no obligation on council once it sees a submission to then go and identify to then notify landowners that here's a submission that you may or may not be impacted by. That's a dangerous route for council to do as well.
Yeah. Just on going back to the weighting of evidence, if we were to give people who didn't submit but then later on wrote in and expressed concerns, then it defeats the whole the procedural process, doesn't it? If you've got a process that's set out, there's requirements on people to file submissions within certain times. So if they simply bypass those procedures and expect to get full weight and have all the rights except appeal rights, then that defeats the whole purpose of the process. I don't want to get too technically.
They wouldn't have appeal rights. On any appeal, they would be limited to lodging a Section 274 notice on another party's appeal.
Yeah.
On the basis that they have an interest in greater than the general public.
Yeah.
But you're right, the Schedule 1 process very clearly sets out the public participation and I think the High Court decision in the Albany North case, very clearly says the onus is on landowners to look through the submissions and work out whether or not they are impacted by a submission.
Okay, thanks for that. Thank you very much.
Thank you.
Just a point of clarity, Ms. Parham. If the OLS is going to be increased in what's being proposed, then that effect on the environment on the neighbour's property would come into play, wouldn't it?
Yes, it would. It's an effect on the environment.
So that would then help the allowance of the neighbour having their opinion heard through a resource consent process, wouldn't it?
Well, they're seeking the OLS through not through the resource consent, but through a new special zone. So I'm.
I get you. Thank you.
Thank you. Just a couple from me, Ms. Lagarde. I suppose the first one concerns Hampton Downs Road generically, and and just following on from what Mr. Cooney said, I mean, you seem to have put a lot of weight on the fact that that area is zoned rural at the moment. But I can't help but wondering, there's probably not a street outside the cities or a road outside the cities in the district that's less rural than Hampton Downs Road, in that it's got a motorsport park, a landfill, and a large prison on it. And I wonder, leaving aside what any provisions might contain, I can't help thinking that sort of going back and saying, but it's zoned rural, is sort of an artificial construct in this case. What's your response to that?
It's not so much that it's zoned rural, but that Hampton Downs Motorsport Park is a special zone that provides for Hampton Downs motorsport activities. And
so I'm talking about the road generally, not Hampton Downs Motorsport Park, but the submissions from just generically the area, not submission by submission, but more. It seems to me that you've said, the zoning of the land in that vicinity is rural, therefore any sorts of rezoning on that road sort of contravene rural land use. And I'm putting it to you that most of the activities on that road are of a scale and nature that bear no resemblance whatsoever to rural activities.
Certainly in the area of Hampton Downs, so where Precinct A is in the Motorsport Park,
yes,
which is directly adjacent, so over the road. So yes, it is of a more urban look and use, but the matters that the issues that I looked at is that they wish to have an industrial use on that site. And so I looked at the higher order documents that identified industrial nodes, and this isn't one of them. And then the nature of the site, so it's quite small in terms of industrial use, but also if it's included in a special zone, the activity, there needs to be some kind of mechanism whereby that activity can be tested against whether it's for the purpose of that special zone. And that's simply because the National Planning Standard applies criteria for special zones, apart from the corrections and airport, but for the Hampton Downs, it's an additional one, and those criteria need to be met. So the activities on the rezoned site would need to meet those criteria, in my view.
Yeah, I'm not just speaking about the motorsport park. I'm talking also about corrections and you know, you made a particular point in relation to corrections and said it's a large site with prison buildings. I'm not sure if that's the right term. I think they called something a bit more woke than prisons, but the prison has a sort of a rural buffer around it.
Yes, so the nature of the correction site is quite different from the Hampton Downs. The correction site is surrounded by rural land. So you will see in Mr. Grace's evidence, he has a diagram of the extent of the prison, which I may be able to show.
No, I understand the point, but what I'm saying to you though is that, you know, you've said that it's rural land, but is it? It's land surrounding a prison that's owned by a prison operator on a road that has a racing track and a rubbish dump bookending it at either end. And I just wonder whether it's all a bit theoretical to be coming back to the overriding rural zoning issue. That's what I'm trying to get to grips with.
So it's in the rural environment, and while there are some urbanised development very nearby, the surrounding land in use in the wider context is rural environment.
All right. Okay. Now I understand the point you're making. Thank you. Just coming back to that point, the correction specific point where you said it's already designated and therefore it doesn't need a special zoning, even though it's possible to do so. Are there any other examples that you're aware of in the proposed plan where special zoning exists in circumstances where there's also designations?
No, I'm not aware of any.
What about schools?
So for a school, depending on its location, it would have a designation, and I believe there's in excess of 50 for the Minister of Education, designations that provide for school activities, and the underlying zone, if it's in a residential area, would be residential.
Okay, I'll have to check. I had thought I recalled that there were special purpose zones contemplated for some school activities, but I may have that wrong. You're saying I have got it wrong in your understanding?
I'm not aware that that's the case.
Okay, no, that's fine. Thank you. Just moving on to the Mercer the Mercer Airport. Is what's proposed there and what occurs there urbanisation in the sense that the RPS and Future Proof define urbanism or urban activities?
It's a difficult one with the airport because you might find farms with landing strips. So it's the range of permitted activities in the proposed zone that are more urban in nature than providing for rural productive activities, for example.
Okay. I suppose the point being, though, that if you were looking to create an airport, doesn't it make sense for it to be separated from large quantities of people? You know, everybody, where there's airports in urban environments, they always seem to create problems. And I'm not trying to downplay the effects on neighbouring properties to the Mercer scenario. But if a facility like this were to locate anywhere, it's more likely than not that it would be remote from large quantities of the built environment, wouldn't it?
Yes, I'm not suggesting at all that this is not an appropriate use. It's provided for by a resource consent, and the effects have been tested through that environment court with evidence and conditions imposed to manage the most obvious effects like noise. So yes, I do think the airport's in the right place and its current scale of effects appear to be well managed. So yes, I wouldn't think in a residential is the appropriate place for this.
Can I just ask you then the hypothetical question? And let's say we accepted your recommendation and said the zoning should remain rural and the existing resource consent were to stay in place. And the airport operators said, well, we still have aspirations to do what we were seeking in the zoning, and therefore we've made a resource consent application or a further resource consent application to implement what we were seeking to implement via the zoning, the proposed zoning. What would the activity status of those activities be in the rural zone?
It depends on what's proposed. So I did have a look at the temporary events, for example, and they're discretionary where they don't meet the permitted conditions.
Yes.
So, yeah, accommodation would be discretionary. Some of the activities would be controlled.
Would there be anything non-complying?
Not that I recall.
Okay, no, that's okay. We can check it out in more detail. But given that there's no planning direction in the rural zone that says the sorts of activities that are being proposed aren't really appropriate, e.g. they're not non-complying, they're able to be assessed on their merits.
Yes.
And in some cases, maybe even have to be granted subject to conditions if there's controlled activities. Doesn't it make more sense to create some certainty around what might happen in the future rather than perpetually wonder what the next resource consent application might look like?
It would provide certainty to people looking at the plan about what activities are occurring there. And that is partly why my recommendation was to, if the panel are of a mind to go down the special zone route, to reflect the resource consent conditions as conditions in the rules. So
yeah, no, I understand that. And it begs the question of, exactly what the zone might allow and not allow, depending on the effects. And, we can ask about that in due course. But it does seem to me that in a situation like this, it would all things being equal, and they're not necessarily all equal, but all things being equal, it would be better to create certainty by creating some rules that relate to future expansion scenarios than leave it hanging and wait for a resource consent to come along that might do who knows what.
Yes, that would provide a framework within which the airport could operate. That I think would be helpful to be aware of.
All right, no, that's very helpful, and thank you very much for your Section 42A report and your summary. I should also just say, for those that are listening, when we talked before about our time limit of 10 minutes per speaker, that doesn't apply to the Section 42A report, because that report by its very nature has to address everything that's put in front of us, as opposed to the individual speakers on a much more confined basis. So the fact that this particular part has taken a fair chunk of time shouldn't be taken by submitters as license to spend considerably longer than the 10 minutes that have been allocated to present to us. So I just want to make that point before we move into submitters. But thank you very much, Ms. Lagarde. That's very helpful. Appreciate it. Thank you. Which brings us to you, Ms. Semple, on behalf of the Department of Corrections, please.
And before that, Mr. Chair, I need to excuse myself from this part of the hearing.
All right, thank you.
Thanks, Sue. Thank you, Commissioners. I just wanted to point out just before I commence that we've got Mr. Gifford from the Department of Corrections on this Zoom call. The Department of Corrections technology doesn't easily accommodate Zoom, and so I also have available to me, but unfortunately not visible to you, Andrea Miller, who is the Manager of Resource Management and Land Management for the Department of Corrections, and Mr. Anthony O'Neill, who's a Principal Advisor for the Department of Corrections and has specific knowledge of the Spring Hill Corrections Facility, if there are operational questions that might be helpfully answered by them. So I just wanted to identify that for you.
Very good, thank you.
Thank you. I have filed legal submissions and I am very alert to the Chair's direction not to read them out. As you have correctly...
Well observed.
As Ms Lagarde has gone through in some detail, the site is already the subject of a designation that provides for the for Spring Hill Correctional Facilities activities, and that designation has recently been rolled over in these replacement plan hearings with some amendment to conditions, predominantly around getting rid of redundant conditions that related to its building and its establishment phase. There is an underlying rural zoning, as Ms Lagarde has talked about in some detail. I think what is important, though, to recognise and understand is that the special purpose correction zone which is being sought here is based on that rural zoning. So the idea that that there is a special zone that would come in and sit over the top and entirely dispense with that underlying rural zoning is not quite correct. And I will ask Mr. Grace, when he gives his evidence, to perhaps just spend a bit of time going through the way that that zone has been developed, because I think that's a critical fact. I do accept and agree, in fact, with Ms Lagarde that if a gap in the plan were created by the imposition of a notice of requirement and a zone which entirely reflected that notice of requirement, that would be a problem. However, I don't think that applies here. And that safeguard is provided by the way that the special purpose zone has been developed, and the fact that activities that are not specifically provided for in that zone default to non-complying activities. So I think as a comprehensive zone, it works within the plan. And as you'll see in the submissions and in the evidence of Mr. Grace, the department considers that to be a pragmatic response to what is a situation that's arisen because those national planning standards came in after the, or were identified and developed after this process had begun. The department has looked at that, will be submitting on plan reviews up and down the country in relation to those, and the introduction of those special zones that will become the default position that the department will put forward. And it's simply really a question of timing in this instance that has come in a little bit later and through a further submission. I agree, perhaps not ideal, but simply the circumstance that we find ourselves in. You'll see that I've set out there in my submissions in some detail, though, that I do believe that there is scope, should the panel wish to accept the submission. I don't consider that you are jurisdictionally barred from doing so as a result of other submissions that have been lodged in relation to these matters. And I'm happy to answer questions in relation to that, but I suspect that from the questions that have been asked to date, that the panel's interest is more in understanding exactly how this zone would work if it was imposed, and whether it would create the gap in the plan that Ms Lagarde is concerned about. My answer to that, and I'll have Mr Grace confirm this, is that it would not create a gap in the plan. What it would do is create a much more straightforward, transparent zoning that reflects what is actually happening on the site, but does provide for those somewhat unusual circumstances in which an activity might also be sought, which is not covered by the designation. That's pretty unusual, and particularly for the Department of Corrections. Obviously, for the department, the activities that it sits alongside its correctional facilities are carefully managed and carefully chosen. So it is unlikely to be using the balance of the site for for inconsistent purposes. At the moment, although the correctional facility buildings, I am still inclined to call them prisons as well, Mr. Mitchell. Those correctional facilities do take up a small part of the site, but the balance of the site is predominantly used for farming purposes that are part of the way that the prison is run and are used by the correctional facility as part of its work with the people it serves. I wonder if there is more that I need to say. I am minded to answer any questions you have and then to hand over to Mr. Grace, because I think the mechanism of the plan and the way that zone would work in practice is probably the most critical question. But I'm happy to be in your hands in respect of that if you would like to hear more from me, or indeed if you have questions of me.
I think what we might do is hear from, if you have no objection to this, hear from Mr. Grace first, because that will round out the picture, because absent the factual matrix,
yes,
the legal framework is simply that, a framework.
That's right.
So I'm wondering if we hear from Mr. Grace and then we can ask questions of you both.
Could I just ask
anything? Yeah, Mr. Cooney.
Mr. Chair, could I just answer just a question, just it might help us before Mr. Grace goes down to explain the planning background there. Just one question.
By all means.
Thank you. Just from what your description is, what you're saying is that what you're proposing is really a type of hybrid zone. When you break it down, it consists of the designated activities as with the amendments you're seeking, plus the rural zone provisions. Is that an accurate summary of what the zone will be?
I think that's exactly right. I think there's a tendency when we think about the national planning standards to imagine a sort of a fully formed zone that sort of comes in and applies right across every site. That's not what is anticipated. The national planning standards actually anticipated that there would be the sort of the rounding out, I guess, of that zone, which would take into account the environment surrounding it. And so that's effectively what Mr. Grace has done in developing this, is take the existing zone, which does have some continued utility given the surrounding area, and then provided that overlay of the actual activity that's taking place within that site. So I think a hybrid is, as a lawyer, I'd say a hybrid zone is a good description of it. I'm desperately looking at Mr. Grace to see if he agrees with me, but no doubt he will tell us if he doesn't.
Okay. Thanks very much. Thanks, Mr. Chairman.
Thank you both. All right, Mr. Grace, let's hear from you, please.
Okay, thank you, Mr. Chair. Just before we go into the actual the formulation, I guess, of the zone provisions, just to touch on the timing of the gazetting of the national planning standards and the way that sort of panned out. So the primary submission period on the proposed plan had closed, and it was subsequent to that the gazetting of the national planning standards occurred. So we took the opportunity in the further submission period to make our point that we would like to have this special zone imposed. So just a quick note there.
Thank you.
And in terms of the way that the provisions were formulated, yes, it was to use that point of a hybrid zone. It is very much that. The underlying rural zone or existing rural zone provisions were completely uplifted and simply reapplied in the correction zone context, but with the application of 3 specific activities. And I would like to make the point that these could possibly be considered to be provided for under the designation, but there's that grey area there that we just wanted to clarify. Plus there is also the, I guess, the evolving nature of corrections activities as well, which the department can talk to if needs be. But what we have done is to cover those eventualities. The other key point being, and it has been asked in questions to the council planner, is that it does provide a planning framework for which to look at any future changes to the designation which may occur. So simply, if you were to consider a future change to a designation, for instance, an expansion of the prison, that would be looked at purely in a rural zoning context, and you're essentially coming up against a brick wall in terms of that policy and objective framework. And we have experienced that with the expansion of the Waikeria prison, just south of Te Awamutu. To go back to the original question, which is what are the activities that I guess are nuanced from the rural zoning, and there's 3 of them. So
do you want me to share? I've got your summary statement on my screen. Would it be helpful if I share that?
Absolutely, yes, that would be helpful. I was just going to touch on those 3 key points.
Well, let's have it. So that we can all see them.
So it's just paragraph 1.8. Oh, okay.
I was just going to let. Well, you tell me where you want to go. I was going to. You said you wanted to talk about the rules.
Rehabilitation.
Yeah, I think that those are them there. Absolutely, those are the ones. So what you're seeing here is essentially all of the allowance for the same activities as per the rural zone. And I think there was a question earlier around whether farming activities, as an example, would require consent. And that would not be the case because we've provided for exactly the same rules. There's linkages to all the rules for the rural zone, for instance, and it comes down to these 3 activities here. And I guess to provide a bit of context around them, so the first being non-custodial rehabilitation activities. And in essence, these are programs which are generally undertaken outside of the secure perimeter of the prison and involve, work skills, could involve cultural programs. I guess the key example on the Spring Hill Correction Facility site is the housing refurbishment yard. So that's just to the north of the secure prison. And it's essentially a yard where houses are relocated and are worked on by the prisoners. They learn trade skills, and then those houses are taken off-site and relocated. So that's one example of an activity that would fall under that particular category, and it's an existing one on the site. Another one which would in all likelihood be considered a permitted activity under the rural zone anyway would be the prisoners working on farming activities and learning farming skills. The second one we have there is the community corrections activities. These are essentially service centres that provide for probation, rehabilitation and reintegration services. So very akin to activities which are taken around the administrational side of the prison at the moment, although it's more focused on the people who have left the care of the department. The third one being supported residential accommodation. And this is the one that we had to give quite a bit of thought and I guess provide a real framework around in terms of a permitted activity status. And this is becoming, I guess, an increasingly, it's an activity which we're seeing more and more of around the country because of the shift away from, I guess, the Labor government. I don't want to get too ahead of myself here, but I guess I'm dealing with it on a more day-to-day capacity around the country where we're looking at consents and or certificates of compliance, for instance, to establish these residential accommodation units all around the country because there's been a move away from the Labor government from incarceration and more into the community space, providing these rehabilitation and wraparound services. So in essence, the housing for and support for people in the department's care following their release from prison, and allows department staff to provide those wraparound services as well as other social services. Now, in the context here on the Spring Hill site, is that we have existing self-care units which sit outside of the wire, outside of the secure perimeter, and I guess the difference here is self-care units being for people who are still subject to a custodial sentence. The supported residential accommodations for people who have finished their custodial sentence but might be subject to some kind of community-based sentence, home detention, the like. They don't have other places to go. But what we did here is applied the same area of the Spring Hill site. These types of buildings or dwellings could actually be established into the same area that was identified originally in the designation as where the self-care units can go, as well as restricting, as you see here, numbers to 30 residents at one time, no more than 5 of these units or dwellings within that particular area of the site, and point D there, or clause D, being that area which is referred to in a plan which is provided for under the designation. Just to touch on so those are I guess the key activities, and the only activities which differ from those which are provided for in the rural zone. Yeah, I guess just to highlight, I mean, there's a high degree of overlap between the designation and the proposed correction zone, and the difference in those potential effects between the permitted activities, the 3 I've just described, and those explicitly provided for under the designation are minimal. If I could just go through a few points which I've picked up through questioning, just to possibly short circuit any further questioning there. I've touched on how the policy basis is there to assess any future changes to the designation. I think that's a really key one, and something that's not obviously provided for if the underlying rural zone were to be retained. There was another question just around what other special zones around the country apply where requiring authorities also have designations. And there's 2 that I'm aware of, and those are hospitals. And I've actually given an example, I think, in my rebuttal statement, which was where the Tauranga Hospital is designated to the Ministry of Health, but also would be allowed a hospital zone or special hospital zone if they were to seek that. The other one is airports, and I guess that's more pertinent here in that airport authorities also have requiring authority status, as well as the ability to seek a special airport zone as well. And just the final point, and Ms. Semple's already covered it, but we are very active in the space of seeking the application of the correction zone. Now that it's a tool that's available to the department, we're actively seeking it at the moment through a submission on the proposed Selwyn district plan. That's in relation to the Rolleston prison. We're in close discussions with the Wellington City Council around the application of the special zone to the Arahata prison in Tawa. And yeah, I mean, and there's another 16 or so sites around the country with correctional facilities that, as we move into plan reviews, we'll be going into discussions and certainly looking to use the correction zone on all of those sites around the country.
Very good. Thank you, Mr. Grace. It's a very helpful summary. Thank you. Let's see if the panel has any questions. Can we start with you this time, Mr. Fulton, please?
Yeah, no, thank you. I don't have any questions. Thank you.
Mr. Marg?
No, thank you, Mr. Grace. You're very clear. The intent is quite simple in my view. And so thank you very much.
Ms. Gibb?
Yes, my only question had been about New Zealand consistency, but you've answered that now, so thank you.
Thank you. Mr. Cooney?
Thank you. Thank you, Mr. Grace.
Oh, you don't have any questions, sorry. I've just got a couple, and I'm not sure, maybe I could, well, I'll leave it to you to figure out how to who answers this. Can I just put this these provisions back on. Can I just want to clarify the permitted activities P2, P3 and P4 that are proposed. P4 seems to relate both to the building of supported residential accommodation and the activities that then are undertaken within them. That's my understanding of that correct?
Yes, that is correct. So we've applied, rules in relation to numbers of buildings as well as the location. Yeah, that's correct.
That's what I thought. What's the situation though? What's not so clear to me is P2 and P3. They talk about the activity, but they're silent on buildings within which they operate, assuming that there are buildings, and I assume there are. Is that intentional, or is that something that needs to be addressed?
Look, potentially that's something that needs to be addressed. I mean, my take on this, particularly in relation to community corrections activity, is that that's most likely to be an activity that would be undertaken within existing prison facilities.
Doesn't say that though, does it?
No, and I'll take the point there, sir. Yes, and in relation to non-custodial rehabilitation activities, that's probably likewise in terms of their location likely being within the existing facilities. There needs to be a degree of flexibility, as we don't know. The corrections or the rehabilitation space is a changing space, and that is perhaps something we need to look at and give the council and surrounding community a bit more certainty there. I mean, we'd be pretty happy to accept the rural zone bulk and location standards, which apply anyway by virtue of the standards above, which we've applied directly from the rural zone. But if there was a need to, I guess, impose a further restriction, then we could look at doing so.
Do you think though, following that up, that 1C above actually addresses that anyway? Is that what you're saying?
Yes, well that's it. The rural zone bulk and location standards, for instance, are applied through that.
Yes.
But actually we could look at something as a further restriction, was that deemed to be necessary. Whether that is the case, I guess would be something we need to determine.
All right.
Yeah, but it's very much that 1C is the application of exactly the same rules that apply to the rural zone anyway.
Okay, no, that's helpful, thank you. Just in my final question, are non-custodial rehabilitation activity and community corrections activity, are they defined anywhere?
In terms of community corrections activity, very much so. That was a defined term that was brought in through the National Planning Standards, and we've given evidence in previous hearings on that.
Yes.
In terms of where it is appropriate to apply permitted activity status to those through the zone hearings. Non-custodial rehabilitation activities is not a defined term at this point in time. No, it's not something that is defined. We have given a proposed definition for that, I know, through Selwyn, our submission on the Selwyn district plan. So again, that's something that we'd be happy to provide, follow-up evidence on if determined to be necessary.
Well, I don't know what a non-custodial rehabilitation activity means, and rehabilitation presumably means prisoner rehabilitation rather than rehabilitation of farmland to, native bush. And I don't mean to be cute about saying that, but there does seem to be a bit of a term of art in at least P2 that you might know what it means, but I'm not sure necessarily that a planner at the council would automatically understand it.
Yeah, no, I will take the point there, and we're happy to provide the proposed definition for that as per the submission on the proposed Selwyn plan, if that was to be helpful to the panel.
Well, I don't know what the Selwyn plan submission says, but I think if you're able to provide us with definition and clarity around those matters and the earlier ones to the extent that you think it's necessary on buildings, then that would be helpful, I think.
Take that point and we'll come back to you on that. Be able to come back to you.
That's great. Thank you.
Today. Yeah.
I don't have any further questions. Is there anything arising from the questions that the panel might want to revisit?
Yes, just on that line of questioning, Mr. Chair, P4, supported residential accommodation. What does supported mean?
So supported means the ex-offender being supported by the department. That may be by their probation officer, psychiatrists, psychologists, those wraparound social services. That's, I guess, at a high level what it and relates to staff on site that can provide those services. So that's, I guess, the long and the short of it. Supported by the department in a roundabout sense.
Okay. Would that include housing for staff as well?
There may be an element of supervision and people actually living on site for specific periods in a supervisory role, or it may not. Or in fact, it could even be a third-party service provider, social services, which we do see around the country as well. It really depends on the level of support that's determined by the department to be necessary for the individuals.
Just hypothetically, is it possible you get a whole proliferation of residential homes, both for rehabilitation purposes and also for staff, low-cost housing as part of the salary package going in there? And if so, what sort of controls would be over that situation?
Okay, well, I guess firstly, in terms of any staff and dealing with that particular, that would be subject to the link back to the rural zone provisions and would come down to those things that would, for instance, the restriction on number of dwellings on site. So that would be your restriction there. And in terms of the proliferation of these kinds of things, that was something we were very conscious of, Mr. Cooney, and that was why we have proposed those conditions under P4, particularly around the number of residents that can be on site at any one time, as well as the number of units that can be provided for in terms of supported residential accommodation.
Yeah, I'd overlooked that provision, so thanks for that. Yeah, okay.
And just the final point, I guess, in terms of staff housing, corrections policy is no longer to house any of their staff on site. All of the prison officer villages, the likes of that used to be on site at Waikeria, for instance, they're all gone by through central government policy.
Yeah. Okay. Thank you.
Just one follow-up from me, just for the sake of completeness. Is supported residential accommodation defined in the National Planning Standard?
That one's not, sir. And again, we do have a proposed definition around that. If that I can provide, if that
would be helpful. Yes, please.
That would be helpful.
Yeah. Thank you.
All right. Look, that's very helpful. Thank you, Ms. Semple. Is there anything that you want to add at this point?
No, sir, I don't think so. I think your questions have been answered, and as Mr. Gray said, we'd be very happy to provide a definition or definitions in relation to those two activities, which are not currently defined in the National Planning Standards.
All right, and we'll leave it to you to consider whether the 1C reference to buildings and so forth is sufficient, or yes. Mr. Grace suggested that it might be helpful to clarify those. We'll leave that to you to consider further.
Yes, thank you, sir.
All right, thank you very much. That's very helpful. It might look from the hearing schedule that we're a little bit behind time, and in one sense we are, but only in relation to when we take our break. So I think what we'll do is that we'll take that now and we'll resume at 11 with Ms. Nairn for TKDM Farms Limited. If you could please, if you're proposing to stay on in the hearing, and obviously the corrections folk are free to go if they wish, if you could just mute your sound and turn your video off. That's better than logging on and logging off just in case there's problems with reconnection. So we'll adjourn now until 11 o'clock. Thank you. All right, no problem. All right, welcome back, everybody. We're now up to Ms. Nairn on behalf of TKDM Farms Limited. Thanks.
Good morning, sir.
Morning.
Thank you to yourself and the panel for giving me the opportunity to speak today. I've listened in this morning to the comments from Ms. Lagarth this morning, so I'm not going to go over the background to the proposal. I'm also well aware that you've read the evidence, so I'm not going to go into those details again. I am, however, going to make a couple of quick comments. The first relates to growth, in that I see this site in Mercer as having the ability to contribute to growth, not so much in the form of numbers. Obviously, this is a very small proposal compared to other sites that you're looking at, so it's not the silver bullet in terms of providing the numbers needed to meet the national policy statement, but it can contribute as an alternative and growth in an alternative location, because there are people who will want to move to the Waikato that will see Pocono or see Te Kowhara as larger places, and they will want to be part of a smaller rural community. And this site has the ability to provide an alternative for those people. And that's important when looking at growth. You can't just provide growth in terms of a quantum or numbers. It's important that growth is provided in a many range of ways and in a range of locations. The second point I'd like to make relates to Mercer itself, in that when you look at Mercer on the planning maps and when you go there, you realise it's a relatively complete community, in that there's residential land, there's business land, there's community facilities such as a school, but yet Mercer hasn't thrived in the same way that other places have. And in my view, that comes down in part to numbers. And if we could increase the population in Mercer, it would have the ability to perhaps grow and expand and attract a few more activities, attract a bit more business, and really become an enhanced community. So I see it as having benefit both in terms of growth and in terms of the community itself. Yeah, that's me.
Very good. That's short and sweet, but I think we get the message and get the points that you're making. Let's see if we have any questions for you. Can we start with you, Mr. Marg, please?
No, nothing from me. Thank you, Ms. Nairn.
Mr. Fulton?
Just one question. The residential area of Mercer is very split, isn't it, with the main highway, and the facilities are on the western side, and the eastern side is where you're trying to develop a bigger, and that's where the school is and that sort of thing, isn't it?
That's correct.
You're wanting to increase that residential area around there, and that's the only place it can grow, isn't it, in many respects?
That's right. And I mean, when you drive around, it is a relatively constrained and limited settlement in terms of growth. So I see this as a good spot. It connects up to the school and it connects between the existing residential.
The site itself is, it's got the transmission lines over it, but it is also reasonably hilly, isn't it? It's reasonably steep.
It is reasonably steep. We have had a geotech report done on the land, and that has said, look, you know, there are the standard types of geotech constraints, but they're not insurmountable, and it's still feasible that it is developed. You know, the Mercer itself, the whole of Mercer is relatively steep as it comes down to the river. So it's, you know, proven that development can happen in Mercer, and it has happened, and I'm sure it will continue to happen.
Yeah, so the sites themselves would be not very dense. I just can't recall the numbers, 18 to 20. Is that still about right for that site? So
Agreed.
yeah.
Yeah, we haven't done the detailed design. In part, that will be determined by what yourselves come up with in terms of the minimum lot size you put in place in the village zone. But it isn't as dense as the main part of the Mercer settlement, but that density then, lack of density, gives that flexibility to work around constraints like the geotech and the transmission lines.
And your access was going to be off Koura Road, was that correct?
Yes, yes. The other road that you see coming off Glass Road is actually an unformed road.
Okay.
Yeah.
Right. No, I'm reasonably familiar with the area you're talking about. So no, thank you very much.
Thank you.
Thank you. Ms. Sedgwick?
Thank you. Thank you for that. And thank you. I do appreciate that you were very short and sweet, but you covered everything. Can you tell me how many houses are currently, or how many dwellings are currently in Mercer, roughly?
I can tell you there's around 140 people.
Yes.
So if we divided that by 2.6, well, we'll guesstimate there to be around 70, I imagine, or 60 or 70, I guess.
Quite tiny. And are you talking, even though you're asking for a village zone, are you talking about up to 5,000 square metres to get your 20 sites out of 10 hectares?
Yes, I mean, there would be, so the village zone has a minimum, so we, depending on what the panel put in place, I think the planner's recommendation was down to 2,500 square metres. It was notified at 3,000, so look, we could be anywhere in that sort of ballpark, but that will be a minimum, and I'd imagine on this site they'll be slightly larger. They'll be more around the 3,500 square metre type size.
And the infrastructure in that area in terms of water and wastewater, can you comment on that?
Sure, there isn't any, but the benefit of the village zone is that the sites are large enough that it can be provided on site.
Right, okay. And just finally, how far would it be from, say, that intersection with Glass Road and Koura Road around to, say, the on-ramps at the expressway?
Well, I think
a kilometre?
I don't think quite that far. Fletcher could actually measure it off. But I can tell you that if you took the corner of the site, that's it. He's doing it for you. Magic. Thank you, Fletcher.
Reasonably, though, a road may not go out of the topmost corner. So if it went out around about there.
Yes, that's
right. Trying to work out. So it's as Commissioner Fulton says, it is quite a hilly terrain, and the road is.
I agree. It is
one way before it goes the other. Yeah. Yes. Any idea, Mr. Bell?
Sorry, I thought you could see.
Oh, I could see it, but I just couldn't see the number.
I think it adds up to about a kilometre.
Okay, perfect. Lovely. That's all from me. Thank you very much, Ms. Nen.
Thank you.
Thank you, Ms. Gibb.
Yes, thank you, Ms. Nen. I actually was thinking about the services as well, because it's obviously not going to be in the very near future any likelihood of the services. So it will have to be obviously village or country living or something along those lines. So there is a comment by the planner about the S42A report writer talking about the distance from the village, but in theory it's walking distance, isn't it? We've just discussed it's a kilometre to the expressway. So it is within walking distance. And how far from the school? It's really just across the road, is that correct?
Yes, so the school is where the C50 is. That's the designation on Glass Road for the school. So it's just across the road. So people are moving up and down. I agree it's a steep street, but people are moving up and down there already with their kids to take them to and from school. So Fletcher's just measured off 327 metres from the middle of the site that we're looking at to the school across the road.
And is there formed footpaths there?
There isn't a footpath there at the moment, but I'd expect if we were able to, if the site was able to be developed, it's something that could be imposed through the conditions of the consent.
And so where do the children from the school, where do they live? Are they just local or are they from all around the farm area?
Look, I'm imagining that they're local, but they could well come from, you know, there's a slightly wider area.
And do you know the numbers of children at the school or not?
I think there's only 49 at the moment.
Okay, all right, thanks very much for that clarity.
Thank you.
Thank you. Mr. Cooney.
What's the property used for at the moment?
It's just a farm. It's part of a wider farm. So
and yeah, okay. How big's the farm?
Oh, it is big. Hang on.
It's on the figure in your
in my evidence.
In your summary statement, but I can't quite read it on my screen.
It's 390 hectares.
It's a big farm. Hey, what's the soil quality? What is it?
So we've looked into it. There's no high class soils on this portion of the land. Can't comment on the wider, larger farm, but on this portion there isn't high class soils. It's quite rolly, quite dry hill country. And
do you think this, you know, village zoning would have a great deal of appeal with the lines going through the property?
Look, I agree the lines are a constraint, but they are something that travel up and down the country, and there's plenty of examples of houses around high voltage transmission lines. I think we'd need to be careful and cognizant how we laid it out so that we could, you know, have a good frontage and locate things so that we worked around the lines rather than being too close to them. But the New Zealand Code of Electrical Practice sets out some very clear standards, and if you meet the standards, then they're met. So there's ways forward to do that. As to the attractiveness, look, it's funnily enough that when you go there, the lines, in some cases, when you look at a site, the lines are a really dominant feature. For some reason in this site, they don't become quite so dominant. Maybe it's because they travel sort of down the slope and across, and the span's quite wide. I'm not sure, but look, they're there, and I'm sure we could develop around them.
Did you do a Section 32 AA sort of analysis on it? Of you got this area part of a large farm, productive farm, vis-a-vis putting this, making it almost an urban type development under transmission lines.
Yes, I did do a Section 32A report. It was attached to the primary evidence. The reality is that the landowner owns a large farm. They are quite they don't really, this part of the block isn't sort of overly well used, so they're quite comfortable with the productivity and the capacity of the remainder of the farm with this portion coming out.
Okay, thank you.
Thank you, and I have no questions. Thank you very much, Ms. Nairn.
Thank you.
And that brings us to Mr. White for Reed Investment Trust.
Thank you, Chair, Commissioners. I wonder, just to help everyone, if Mr. Bell could put that plan up of the site that Ms. Legarth shared with us this morning. So the Reed Investment Trust is that site that's highlighted in red there. So this is not a rural site. Its neighbours are a motor racing park, a service station, prison and a landfill. It's a small, oddly shaped site that was earthworked and metalled at the same time as the racecourse was built. And since then has only been used sporadically for parking associated with the raceway. And it also contains the potable water supply tanks for the raceway. The Reed Investment Trust is an entity associated with the Reed family. Ross Reed Contractors did the earthworks that created the raceway for the original developer of the raceway. And one of the sons of the family, Johnny Reed, is a leading New Zealand racing car driver, and the family have an apartment at the track. The family have designed a small development on the site which only achieves approximately 5,000 square metres of warehouse GFA. I had a figure of 7,000 in the submission and evidence material. We've since gone now to the extent of designing resource consent plans, and we're only achieving 5,095 square metres of warehousing. And proposes simply clean industrial activities. The site can be self-sufficient for infrastructure, notably 3 waters, and also the traffic effects of a development of that scale, as endorsed by Hampton Downs traffic consultants and NZTA, are insignificant. I've outlined 3 options in the 32A analysis for the reasonable use of the site, they being a spot industrial zone, to include the sites within the existing precinct E, which provides for industrial activities, or include a new precinct specific to this particular site. Of those 3 options, I'm of a mind that the most appropriate planning response is either of the latter 2. And I know that Hampton Downs Motorsport Park prefer, if anything, that it was included as a separate precinct, which we've called precinct F, and I've tracked some changes to the provisions as part of the evidence to enable that to occur. The fact that the site wasn't part of the land that the raceway are wanting to include in the precinct isn't the end of it. Other land can be included within the precinct, and indeed that's what the Reed family had thought had occurred many, many years ago. Criticism has been levelled at the linkage of the use to the objectives and policies of the precinct. To that I say the existing industrial units within the precinct have very loose linkage in planning terms to the use of the units. That having been said, the units are most likely to be to appeal to folk somehow involved in motorsport or other proximate activities. The other criticism is the fact that the site isn't in an area identified for industrial use. I accept that. My only response is that this site can only achieve circa 5,000 square metres of warehouse space, so isn't going to undermine a centres-based approach. So all told, I'm of the mind that I've suggested a pragmatic planning response for the reasonable use and future of this site, and invite any questions from the commissioners.
Thank you, Mr. White. That's pretty clear. Let's see if there are any questions for you, though. Can we start with you this time, Ms. Gibb?
No, nothing from me. It's quite clear.
Ms. Sedgwick?
No, I'm just trying to correct what I think is, pardon me, an anomaly on your planning map, where I think you're calling State Highway 1 Hampton Downs Road, if I'm looking at your map. So it's a piece of land. I think I understand where you are, the piece of land next to the Gull service station and over the road from the Hampton Downs Motorsport Park.
That's correct.
Okay, it's just that's what's confused me suddenly. Thank you very much. No, I'm good.
Thank you. Mr. Marg?
No, nothing from me. And just to be, you're only looking to put 6 units on the 6,700 square metres. Is that, just to be clear?
The site's only 1.3 hectares, and we achieved 5,000, in the latest plans, we achieved 5,095 square metres of warehouse and 289 square metres of auxiliary office.
Right. Thank you very much.
I should also add, and a bunch of car parks that would remain available for major events for Hampton Downs.
Yes. Thank you.
Thank you. Mr. Cooney?
What's the current use of the site? I know it's been used as a park for Hampton Downs, but what's it been used for at the moment?
It's a metalled yard that's laying idle, other than for parking during major events.
And if we were to refuse the submission, what's going to happen to the land?
It will remain idle.
Okay, it'll just sit there.
Correct.
Okay. Thanks, Mr. White. Thanks for the way you've described it.
Mm.
I have no questions. Thank you, Mr. White. It's pretty clear. Thank you.
Thank you all.
Which brings us to Hampton Downs or HD Land Limited. Thanks.
Yes, my name's Paula Rolfe, and my qualifications are identified in my original evidence, and I'm just relating to the highlight statement that I have presented to you, which I'll just go over. In addition, we also have Josie Spillane here, who's the Chief Operating Officer for Hampton Downs, as well as the Highlands Park in Christchurch, who is available for any queries that may pop up by the commissioners.
Thank you.
So Hampton Downs seek to retain the zoning of the Hampton Downs Motorsport and Recreation Zone as proposed. So Hampton Downs opposes the submission by the Reed Investment Trust, which seeks to rezone the site from rural to the motorsport zone, and to include the site within Precinct E, as well as to change the zoning provisions to cater for future industrial development on Lot 6, as shown on the map within the highlight statement, and also just identified by Mr. White. So evidence on behalf of the Reed Investment Trust, which was prepared by Alistair, has undertaken a Section 32 analysis of the site, identifying 2 rezoning avenues of the site. And these include to rezone the site from rural to industrial, or rezone the site from rural to the motorsport park with a new precinct F, enabling both industrial activities and event car parking, or include the site within the existing precinct B. So there's been a number of options floated. So out of those options, Hampton Downs certainly identified their preferred option as rezoning the land to industrial. So generally speaking, Hampton Downs do not oppose the development by the Reed Investment Trust, but any development must be undertaken for sufficient detail to ensure that all reverse sensitivity risk is resolved. So as background to these concerns, Highlands Motorsport Park has been engaged in ongoing regulatory proceedings in order to protect themselves from reverse sensitivity effects. As a result, Hampton Downs land are very conscious of the potential effects and approach development with utmost caution. So Hampton Downs is not opposed to the trust applying for resource consent application for the development they propose, so that all the effects of the motorsport park can be appropriately addressed. And this process has been well underway with Mr. White, as well as the team from Hampton Downs. So for the purpose of assessing whether or not their proposal to rezone the land from rural to industrial, as well as from rural to special zones such as the motorsport zone, the framework report has been used, which the commissioners would be well aware of. So I'm not going to repeat those, the summary of the objectives, which are in the proposed Waikato District Plan. So additional industrial land is not required for the site, particularly as 17 hectares still remains for development in Precinct B of the motorsport zone. The site is not located within a strategic industrial node, and the framework report identifies that at the time of writing this policy, it was relevant when writing the plan, but now it is likely to constrain demand for economic opportunities within the district, and identified that Waikato 2070, being the district's growth and economic development strategy, had subsequently identified future employment growth areas. Section 4 identifies where and when growth can occur, and the Mary, Mercer and Hampton Downs development plan for the next 50 years only identifies the park as a special activity precinct and doesn't identify this for future employment growth. Furthermore, paragraph 134 of the framework report states that growth outside of these growth areas is not contemplated by Council for Zoning or Servicing. The activities proposed by a Reinvestment Trust are purely for industrial purposes rather than specifically for the motorsport park. And the zone has been specifically identified as being for what was consented in 2006. The Section 42A author also concludes in paragraph 222, extending the zone to include the adjacent land is not consistent with the objectives and policies of the specific zone. And that focus on developing a regionally significant motorsport and recreation facility and the operation and development of motorsport related activities, facilities and event, and very specific land use with a specific set of precincts. So within my original evidence, I identified that a lack of evidence was available to support the rezoning of the site to meet the Waikato Regional Policy Statement, including the Future-Proof Growth Strategy, 2009 and 2017 Future-Proof Strategy, which do not encourage industrial development outside of the selected sub-regional areas identified. I also concur with the Section 42A report in paragraph 223, who also supports that the submission to change to industrial zoning is not in keeping with these policy or strategy statements. The Section 42A author also identifies in paragraph 223 that the proposal to rezone the land is likely to fail the criteria and the national planning standards for a special purpose zone. I concur with the author that rezoning will most likely fail the criteria under the national planning standards, as it is proposed use is not of significance to the district, region or nationally. Basically, it is a request to have industrial zoning. So just in conclusion, the motorsport park zone has been developed based on the original resource consent for the park, and the proposed development is not reliant on the land resource or the specific activities of the motorsport park. Hampton Downs is opposed to rezoning the Reinvestment Trust site within the motorsport park zone. The site doesn't align with the objectives and policies of the proposed Waikato District Plan and the principles of Section 6A of the Waikato Regional Policy Statement. The proposed rezoning is not in alignment with Future-Proof Strategy 2009 and 2017, as well as Waikato 2017. Industrial zoning provides an expectation of development which has the potential to conflict with existing or future activities of the motorsport park. Hampton Downs land is not opposed to Reinvestment Trust applying for a resource consent application for the development, and they propose so that all the effects on the motorsport park can be appropriately addressed. The preparation of this application is underway, and representatives from HD Land have been involved in this process to date.
So you're finished.
Thank you.
Let's see if there's any questions. Mr. Marg?
No, nothing from me, thank you.
Mr. Fulton?
Yeah, it is an orphan bit of land, isn't it? I mean, it's small. It's it was the residual effect of the road being altered, and it is pretty minor, isn't it, in the scale of things? Well, that's certainly the way I see it. I think, you know, if it was zoned into an industrial piece of land, it could be used for servicing a garage or something like that on it. Is that right?
Well, as I identified, Hampton Downs' preference would be an industrial zone rather than the motorsports park zone.
Right. Okay. Thank you. Good.
Ms. Gibb?
No questions, thank you.
Ms. Sedgwick?
No, I have no questions. Thank you very much.
Mr. Cooney.
You know, one of the things we've got to look at is the efficient use of resources, and this would be a resource if it wasn't rezoned, it just sits there as a little isolated block. So isn't it the most efficient and effective or most appropriate way to look at this resource, to rezone it?
So Hampton Downs has been working with Mr. White on a resource consent application, and Hampton Downs has been working with them. They would rather identify what actually is going on the site so they can manage the effects. I mean, at the moment, if you have an industrial zoning, that would allow any type of industrial activity to go on that particular site. And one of the concerns, as I said, was the reverse sensitivity effects.
Pretty, you're right next to a large racetrack, and you go into that with your eyes wide open, don't you, if you buy there?
Perhaps
even if you want to got an assortment of industrial uses.
Perhaps if I could make a comment to
Sure.
that, if that was okay. I would agree. You would expect that people go into the process with their eyes wide open. History has proven that to be somewhat different with our other circuit based in Cromwell, appreciating that it was in a different context, but that was a developer who proposed to put 1,000 sections beside a motorsport park, a speedway and an orchard. And that was quite a significant resource intensive process to actually have to work through the reverse sensitivity effects of a development such as that on a motorsport park. Yeah. We simply seek with the Reeds to work with them to understand the use, so we can essentially live in and exist in a harmonious environment without having to deal with the unintended consequences of what such a broad zoning of industrial could be. And excuse if I've got my terminology slightly wrong there, but experience shows for us certainly that sometimes we just can't foresee what could perhaps go up on a site. And we've been very committed to working with Alistair and the Reeds to go through a series of conditions on a resource consent to get good use of that land, just simply not within our motorsport park precinct.
Is it why I think one of the options is to create it into another precinct. Why can't you have controls put in under that? If that's your concern.
I don't know the answer to that. That might be something for Paula. I guess the other argument is, well, the question that I would ask is, why can't it? The park went through a process of a series of resource consents, which have served it well. Why could this piece of land just not go through a resource consent process?
I think things have moved on since then. So you know, we've got to take a real world approach at this. Look, I don't have any more questions. Ms. Rolfe, do you want to answer my point?
Yes, certainly. So at the moment, as proposed, the additional precinct F would require quite a bit of work, because what it is opening up for any type of industrial activity. I mean, even as part of precinct B, there is a lot of restrictions on the type of industrial activity that can be developed there. And precinct E is already developed as industrial units, which are specifically for the motorsport park. They're not any industrial development. And the rules that were worked through 12 months ago or so identified that there are restrictions for precinct E as well, and it relates to the buildings as of 31st of in 2020, I think it's January from memory. So there are restrictions, whereas precinct F's suggested to be much wider than what is allowed in the motorsport park at the moment.
All right, but you're more likely to get a whole lot of panel beaters here, wouldn't you?
Oh, potentially.
Okay. Thanks.
I just wonder if it's a bit disingenuous to compare this facility with, in reverse sensitivity terms, than the other motorsport park that you're referring to, where that's proposing 1,000 residential sections, and this is proposing half a hectare of warehouses. How does that create reverse sensitivity effects?
Perhaps if I can maybe.
Well, no, it's not. It's a question for Ms. Rolfe, because it's a reverse sensitivity argument that she's put a lot of weight on, and I can't see a reverse sensitivity argument. They seem to be entirely compatible types of operations. Industrial activity next to a noisy, invasive motorsport park.
So we don't know what is going to be provided within an industrial zone, for example. Some industrial zones can have childcare centres, or it could have residential accommodation above the warehousing. I mean, this is what Hampton Downs wants to identify, is what is the activity specifically that wants to get developed on that particular site. And, you know, your definition of industrial development is quite wide. It's not limited to warehousing. And I mean, if you're going to create a precinct F and you're limited it to warehousing, then you're not going to get the reverse sensitivity or any reverse sensitivity issues.
You're aware of the trade competition provisions in the RMA, presumably, because this bears a very strong trade competition element to me. And I need to put that to you, because that's what I'm thinking, and I'd rather take that thought away without giving you I don't want to take that thought away without giving you the opportunity to respond.
All the planning documents certainly drive to have this type of development within specified areas within the district, such as Pokeno, Horatu, etc.
But if we took that approach, the motorsport park would never have got off the ground, nor would the landfill, and nor would the prison. It would all be locked up as rural land along the lines of what Ms. Lagarthe's sort of basic premise was.
So
I mean, it seems you want to have your cake and eat it. You want to do what you want to do and then stop someone else doing something that on its face doesn't seem to raise major reverse sensitivity effects. I mean, the motorsport park has residential accommodation, extensive residential accommodation as part of the facility. So it just seems disingenuous to say we can do what we want and somebody else on an orphaned piece of comprising about half a hectare of development land can't. I mean, as I say, I want to give you the opportunity to respond, but it smacks to me of trade competition.
Yeah, but Hampton Downs is quite happy to work through a resource consent application.
But that's not the point. It doesn't matter what you're happy to do.
Yeah, but
I'm raising the point with you, and you haven't answered me yet, that this smacks of trade competition. All right, I'll leave it at that. You don't wish to answer it. That's fine. Thank you very much for your evidence, and thank you, Ms.
Could I, excuse me, Mr. Mitchell, could I please respond to that?
Yes, if you wish.
I would just like to state for the room that that's absolutely not what this is about. We've taken advice from our planners, and we seek to have a working relationship with the Reeds, and we're not opposed to the development of the site. We're simply following advice that an appropriate use to do that would be through a resource consent and not through our precinct.
But taking that on its face, at face value, that's the same position that was advanced at the time that the motorsport park hearing was held. And that's ages ago. And it seems to me that the positions of everybody are exactly the same as they were then.
There's been quite a lot of work done as part
Well,
of
we haven't seen any evidence of that. Your client's position is exactly the same now as it was then.
No, there has been quite a lot of work done between Mitchell, Daesh and Hampton Downs and Alistair White to work through that process.
All right, I'm not going to take it any further. Thank you very much. And we'll now move on and hear from Mr. Dawson. Thank you.
Good morning, sir.
Morning.
Panel members. I'm sitting here with some other folk from Mercer Airport. They're sitting around the table here, and I'll be calling on them as needs be. Sitting right next to me at the moment, though, is Dee Bond, who is one of the directors of Neil Russell Limited, and she's given a statement of evidence. So having listened to the introduction this morning and the presentation of the Section 42A report and some of the questions from the panel, I'm understanding that you're all very familiar with the material that we've provided, and there were a number of questions that came up that I'd like to speak to. I thought perhaps in that context, it might be helpful if rather than taking you through my legal submissions, if I speak to the key issues that I've identified. And then I was going to ask each one of our witnesses to give a brief summary and answer any questions you might have.
That's fine, thank you.
How does that sound?
Sounds very good to me.
I should also say that I have Siva Balachandra, who's the traffic engineer we used. He provided a report that was given to the council in August last year. Whilst he hasn't given a statement of evidence, I've noticed that there were some traffic issues raised in the 42A report and the rebuttal evidence. So he's available here with me as well, off camera, to answer any questions on traffic when we come to that. The first thing I'd like to say by way of introduction is that my clients, Mercer Airport, are very disappointed with the 42A report, its analysis and its conclusions. It'll be evident from the evidence we've presented that this airport is a significant facility. It's something that my clients put a lot of energy and effort into revitalising, and they see it as an important part of the community. Disappointed also that the stance taken by the council reporting seems to be that, well, you've got a resource consent, that's working. Why do we need to look at a special zone? And I would have thought, with the greatest of respect, that the very purpose of a district plan review is to look at the future planning of the district, and to look at how these kinds of activities can be provided for in the future. And as I think a couple of the commissioners have already observed, perhaps giving some certainty to the future. That thought, in my view, seems to be completely lacking in the council's 42A report and rationale. So those are kind of introductory comments. I'd like to pick up, if I may, on the key issues that I've seen remaining in the rebuttal evidence and picked up this morning. The first one, I think, is, well, what does Mercer Airport's current consent provide for, as opposed to what would the special zone provide for? And to answer that, I could usefully direct you, if I may, to Chris Dawson's rebuttal evidence at section 4.1.
You want me to put that on the screen, Mr. Dawson?
I think we can. Yes, if you can.
If Ken Fletcher Bell put it on the screen.
Is Fletcher Bell?
Paragraph 40. What paragraph number was it? 40.
Page 14, paragraph 4.1.
This is the supplementary statement.
And it's Mr. Dawson's supplementary statement.
Oh, Mr. Dawson's supplementary statement. Sorry, I thought you said section 4 report, but I can get that just a moment.
Right.
Yes, look, I think it's very important that we've read a lot of the evidence and things get sort of muddled up and that sort of thing. I'd really like to know what the difference is between what the consent allows and what you're now seeking by way of the zone.
There is. I can put that on the screen right now. I've got it sitting here. How's that?
That's the one. Yep.
That's it. The wonders of technology.
That's why these Zoom hearings are so good, Mr. Dawson.
I thought you may say that to me at some point today. I should say for the record too, in case you haven't picked this up, Chris Dawson is no relation of mine, but just so you realise that.
You're probably both relieved about that, I imagine.
I'm not sure. It could be. So, look, it's fairly self-explanatory. The 1996 consent provides for 100 movements per day on average over 3 months. Contrast that to the special zoning sort. Really the limitation there is compliance with the noise control boundary and the air noise boundary. In other words, it's got to meet the noise limits, and you can have as many number of movements in that as you like. Moving down, the current consent limits operations 7 AM to 10 PM for flights. No longer the case, other than, and this was a point that Ms. Farham made, which was jet flights at night. Those are not permitted under the zone, and they can only occur between 7 AM and 10 PM. So that's the only hour limitation that's proposed under the zoning. Are we able to move the screen down a little bit, sir?
Certainly can. You want to?
So we can skip over the runway length, I think, is fairly self-explanatory. Moving down, we've got the obviously the noise contour. I've touched on that. Traffic numbers under the current consent are 60 vehicles per day. The BDO traffic assessment says that it should be no more than 160. So there's an increase there, but with that, there are also several mitigation measures proposed to ease and improve the access. So that's where we sit on traffic.
Top one.
Pardon?
Do the top one about the OLS.
Sorry, I missed one out. I'm just being pulled on the sleeve. The obstacle limitation surface is something Mr. Park can speak on, but basically under the current consent, there's no consenting requirement or, resource consenting requirement or limitation on adjoining properties that would preserve the flight vectors. The OLS, I'm sure, is a mechanism that the panel's very familiar with. That's proposed under the special zoning. And the reason for that, just to touch on it, is that an OLS can't be secured in any other way. It needs to be included in the district plan. Moving on down, building controls are self-explanatory. Moving down to activities, I heard this morning some confusion perhaps from Ms. McGrath about what was permitted under the 1996 consent versus what's a permitted activity envisaged by the special zone. One of the things I heard a little bit of confusion about was the backpackers accommodation. That, of course, is currently consented to a maximum of 30 people. So ditto under the special zoning. Sum total of those things then is that yes, there are some differences from our perspective. The key differences are inclusion of the OLS, some revision of the noise contours, and the removal of limitation on flight operation hours. Those are the key things. But an important point here, and again, unfortunately, in my view, it doesn't feature at all, really, in the 42A report in the Council's evidence, is recognition that, of course, this airport and the activities that are consented and the effects that are arising are part of the existing environment. They're here already. And I think really the question is, well, what's the difference then between what's currently consented and what's proposed on the district special zone? Bearing in mind that the whole purpose of a special zone is to recognise the activity, and in our view, to allow some flexibility. So those are my comments for now on that.
Would you just take that up, Mr. Chair? Scroll that up a bit.
Right.
Yeah. Thanks. Thank you. Yes, Mr. Dawson. Sorry.
No, that's fine, Mr. Cleary. Are there any questions on that part before I sort of move to the next topic that I'd like to address you on?
No, I think let's carry on, Mr. Dawson. We'll see if we've got any questions at the end, I think. Thanks.
Okay. Second topic is really the status of the neighbours' correspondence and the way in which it's been dealt with. Again, I noted the questions this morning. To a large extent, I agree with Ms. Parham's point of view, but we part company in two important regards. One is that the position that Council took and Ms. Parham's advice reflected was in respect of sites of special significance for iwi. That, in my view, is quite a different thing from what's being talked about here. My understanding is that in that context, Council was looking at notating on private properties, as indeed is quite routine and quite common, sites of particular significance. And had it done so, that would result in some, limitations and protections on what property owners could and could not do. And that, I think, is a compelling reason, if I could put it that way, to listen to the views of those landowners who hadn't previously been involved. However, what we're talking about here is a special zone that's been sought by submitter following the Schedule 1 process. It's been notified, further submissions have been called, and yes, it will have an impact on some of the adjoining landowners, of course, by the introduction of the OLS and the noise contour. But in my submission, that's not the same thing as a designation, quote unquote, over part of your property. And I think we start going down a dangerous slope when there's a detailed consideration of correspondence that's been received after the fact by perhaps well-intentioned people, but that raises a number of issues that aren't, objective, and that seek to express personal concerns with what's being proposed. And it's quite right that neither Ms. Parham nor I had any germane case law on this point. And the reason for that, I think, is because I at least thought it's well understood under the Act, if you're not a submitter, you don't get to be heard. And what troubles me a little bit, without going into detail on it, is the credence which and the emphasis that seems to have been given in the 42A report. And we hear, for example, a concern by Ms. LaGrath that, these people haven't been heard. There may be concerns in the community, and the way to deal with that is by consent application. That seems to be the gist of it. And in my submission, that's not a valid consideration. It gives an emphasis to this correspondence that it's not. So I heard the question asked, I think by you, Mr. Chairman, as to whether it was a question of weighting of the stuff and this correspondence. I think with respect, the first question that you have to ask is, of the issues raised in that correspondence, what is, objectively speaking, an effect upon the environment? So, the effect of noise from the noise contour on the environment would be one example, but that's as far as it goes. I don't think you get to a question of weighting past that, because the fact that one of the neighbours' concerns was that duck shooting might be interrupted, well, that's a personal issue. It's not objectively an effect on the environment, and so therefore there is no question of weighting. So my summary on that point to you is, I think a great deal of caution needs to be exercised in approaching this correspondence. I think it would have been really helpful if Ms. LaGrath had set out the basis on which it was going to be approached, as opposed to simply, including it and then analysing it. So that's what I'd like to say on that topic. The next topic I've written down was, again, from the questions this morning, was, I think, a query from, or a concern, I should say, from Ms. LaGrath that there were activities proposed as permitted under the special zone that if they were to occur at Mercer Airport, would give rise to effects on the adjoining rural zone that were of concern and that were not anticipated by the rural zone, and that the proper way of dealing with that was, by making them consentable activities. In other words, retaining the current zoning. With respect, that is the wrong analysis. The analysis that you are required to undertake is, what is the appropriate zoning on this property, given the activities, given the environment, and given the sustainable management of that resource. There's no presumption at law that the status quo should remain. That's why we're doing a district plan review. And so equally, I find it a really flawed logic to say, well, this permitted zone, activities permitted in this zone may have effects on the adjoining land not anticipated by a rural zoning. That, to me, is a circular analysis. And indeed, your district, and I mean, you were faced with this morning. Everywhere in New Zealand, we have differences of zones abutting each other. We have residential. In Auckland, under the unitary plan, we have light industrial abutting residential zones. It's not an unusual situation at all. I think too, in terms of those permitted activities, the mention was, one particular example was helicopters, and another example was accommodation above hangars. Well, answer to that, of course, is helicopter movements are permitted at the moment. They have to comply with the noise contour, and they would need to continue to comply with the noise contour. And I'm not certain what the effects of a small amount of accommodation above hangars or on the airport would be, that would be of such significance on the adjoining land that they would be a concern. I'm afraid I'm really struggling to understand that analysis and its conclusion. I'd like to just touch on one of the final points that was made in question of Ms. Lagarth, which was along the lines of, do we think that providing for a Mercer airport zone would secure the future of the airport? And indeed, in my view, and it's evident in the submission and in our case, one of the very purposes of this is to give notice to adjoining landowners and in the future that, hey, there is an airport here. It is going to make some noise, and it is going to be allowed to do some things. That is the very purpose of the zoning, and it's really a fundamental point that with respect, I think it's really, really quite difficult to move past. This is about protecting the airport, and in turn actually protecting the neighbours and the community, so that they realise that here's an airport and it's going to continue operating. Those are really the key points I picked up and I wanted to speak to you on. If I've missed anything that you'd like me to comment on, then by all means let me know. Otherwise, I'm happy to take some questions on those points before handing you over to others who are here.
Right, thank you, Mr. Dawson. I think that is pretty clear, but let's see if there are any questions, and it may be that we come back and ask them at the end once we've heard the rest of things, but let's see if there are any questions at the moment. Ms. Sedgwick?
She's removed.
Oh, that's right, she is too, sorry. Ms. Gibb?
The only
thought I had was, have you done any comparisons between Mercer Airport and Te Kowhai Airport?
Yes, we have to some extent. Chris Dawson can speak to that, and it's touched on in his evidence. As I understand it, I mean, and again, in fairness, this does come out in the 42A report, which says, you know, if there is going to be a special zone at Mercer, then some consistency with Te Kowhai Airport provisions is a desirable thing. And we, of course, agree with that to the extent that comparison is appropriate. As I understand it, though, the Te Kowhai zoning was actually in the proposed plan and it was notified, which for some bizarre reason, nobody thought about Mercer Airport. And perhaps, you know, one of my clients' disappointments is perhaps the council should have done. And the other thing is, as I understand it, Te Kowhai has a very, a fairly appreciable and significant urban component and urban land adjoining it. The difference here, of course, is that Mercer Airport's been here for a very, very, very long time in a rural environment. So those are sort of two factual differences, if that helps answer your question.
Yes, I was just thinking about that. All the other airports, like Raglan's another one. I mean, it's a matter of where we draw the line, I guess. So yes, I just was thinking I'd ask your thoughts on that.
Yes, well, we have presented, and it's just been emailed to Fletcher about half an hour ago, a package of visual material that's actually already in the evidence, with the exception of a couple of items in it. One of them is a table that Mr. Hickley has prepared that compares about a dozen other regional airports with what's proposed here, and asked the question, well, you know, are those airports provided for in the respective district plans? Do they have an OLS? And do they have a noise contour? And when Mr. Hickley is speaking to you, I'll ask him to speak to it and we can pull that table out. But the simple conclusion is that out of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 regional airports around New Zealand, out of 15, only one of them is not currently provided for in the district plan.
Okay.
So it's been my experience, Mr. Hickley's experience, the other Mr. Dawson's experience, all of our combined experiences, that airports routinely, whether they're big or small, are provided for in this way of district plans, and that's why we're so perhaps gobsmacked that you know, this wasn't picked up by the council itself.
Okay, thanks for that clarification.
Thank you. Mr. Fulton.
Just a question, under your current resource consent, have you had complaints from the neighbours? And I'm probably referring more to the neighbours who made these late submissions, of which we referred to this morning. But have you had any conversations with them?
So I think there's two questions in that, Sue. One is, has the airport received complaints since my clients took it over in 2012? The answer to that is no. They've done a lot to improve the airport and to work with it in such a way that the air traffic over which they have control, and Ms. Bond will speak to this, but the air traffic over Mercer, the large portion of it actually doesn't come from Mercer Airport, it comes from elsewhere. So my guys have done a lot to manage the airport. They haven't had complaints. Your second question, I think, was, has there been discussion with the neighbours? Am I correct in that?
Yeah, well, I understand you haven't had because you made your submission and probably didn't advise them. But
Well,
that's fine. I don't want to go down that track. But yeah, I was just really questioning whether you'd had much communication with the neighbours.
Look, there has been in an operational day-to-day context, it does occur from time to time, sir. In terms of this submission, you're quite right. We're relying on the RMA process here.
Yeah. Okay, thank you.
Thank you. Mr. Mark?
No, you're very crystal clear. Thank you very much.
Mr. Cooney?
Yes, Mr. Dawson, I'm just interested in the legal argument about that correspondence that came in. And we had a debate this morning with Ms. Parham about her view of that, and you've set out your view in your legal submissions, and there is a difference there, and I'd like to explore that with you. Are you saying that we should ignore that correspondence completely?
I'd like to say that to you, but it's not that wouldn't be fair of me to do so. And no, I'm not saying that. What I am saying to you is that it needs to be approached in a principled manner and with a great deal of caution. I think that insofar as the correspondence raises effects on the environment, and that's a phrase I think we all understand what I mean by that, then it's things that, you know, for example, traffic safety, or noise of overflying aircraft, those types of things are things that would have been picked up in the council's proper assessment anyway, aren't they? But where correspondence says, hey, I can't sleep at night because of aircraft noise, or hey, my property value is going to go down, or I'm thinking about duck shooting. Those are personal and individual things, and they, in my view, are not things that you're entitled to have regard to, because they weren't raised in a submission. So I think the simple way of looking at it too would be, if it raises things that would have otherwise been in Council's Section 42A report applying the Act, then fine. If it doesn't, then that's different, and that's giving status of a submitter. And so I think I've just to reiterate the point, I haven't found any cases on this point, which is perhaps not surprising, because normally if you miss the submission date, you miss the submission date. That's the way it works, and therein lies the caution.
So what you're saying really is you stand back and take a broad view of a broader view of the effects on the environment without trying to narrow it down into a more subjective approach as to the impact on individuals.
Yeah, could I perhaps reply? Perhaps instead of using the word broad, I'd use the word objective.
Yeah.
And so, well, again, another example that, you know, perhaps easily understand. 55 dBA, you know, it's a noise level, right? And Mr. Headley and the New Zealand standards say that for an airfield, that's an acceptable noise limit for a residence. An individual, though, living in that house might say something quite different, mightn't they?
Yeah.
So I think it's right of you to say, well, what is the noise impact going to be on these surrounding properties? But that's as far as it goes.
So in some ways, it does go back to the weight of evidence, or what value you place on that correspondence, doesn't it? In the end, we don't have any primary evidence, and I agree with you. You look at things objectively, and in that context, you then say, well, okay, we've got to look at this stuff in that context, and then we make our decision on the level of impact, don't we?
I'm viewing it a little bit more simplistically, sir, but I say either the issue raised in an issue raised in the correspondence is in, because it would have featured in Council's Schedule 1 assessment anyway, or it's out. Again, I mean, let's go through the duck shooting as a particular example that's in there, right? So I would say to you, well, the impact on duck shooting, somebody says, I'm not really going to go and shoot ducks, is not a matter that would have fallen into Council's consideration under Schedule 1. And if it's in or it's out, then I'm not sure how a question of weighting arises. And then if you say, okay, well, the issue's in and they're concerned about aircraft noise, how does the question of weighting arise if it's not evidence? These people aren't making a submission. So surely all that they get to raise is an issue that would have been there anyway, in which case council has to evaluate it, or not. With respect, I'm not really understanding how the question of weighting even comes into it.
Okay. I think what I was trying to explore was the issue about the duck shooting. Well, we'd look at that objectively and think, well, in the context of what's been applied for, it doesn't have a great deal of relevance.
You and I probably get to the same conclusion, sir. But I guess my first question would be, in that context, is duck shooting something that council would have considered as an effect on the environment that it had to evaluate, but for it having been raised in the correspondence?
Yeah, it's got to be relevant. Look, I don't want to get into a legal to and fro. I don't think I disagree with you in what you say. I'm just trying to refine it down a little bit more. But generally, I agree. There's a process set up for people to file submissions, and if a too liberal approach to that is taken, then why even have that process?
I agree with you, sir. And first principles, the Act is really, really clear on this, which is why I sort of somewhat glibly said, I'm not surprised there aren't any cases on it, for exactly the reason you've given.
Okay, thank you.
I don't have any questions. Thanks, Mr. Dawson. Thank you for your submissions.
So what I'd like to do with your indulgence is just ask each one of my witnesses to just come forward and give you a little summary if it's needed, and to answer any questions.
I think that's very helpful. What I think we'll do is we'll hear from them all as a package, and then we'll see what questions we have, because a lot of the issues sort of overlap to some degree. So yes, we won't ask questions of them individually. We'll do that at the end, and whoever's the best person to answer it can do that. Okay, so the first person I'd like to introduce to you is Dee Bond, who's sitting here with me. She's given statements of evidence. She, of course, is one of the directors and is exceptionally passionate about aviation in New Zealand and about this facility.
this is their baby. So with your indulgence, I've invited Ms. Bond to just speak to you briefly about, where they're coming from.
Good morning. Thank you for this opportunity. Can you hear me all right?
Yes, we can. Thank you.
I guess the journey for us started almost a decade ago, and we approached council at that time and looking for guidance about how best to proceed with having just purchased a very rundown facility. At that time, we identified that the usage wasn't consistent with the resource consent, so we went through a process of amending the resource consent so that it was consistent with how it was actually being used, but also how it had been, the original application had anticipated. We were then encouraged by the district council to go through this zoning process as part of this district-wide review. So I guess I found it a little surprising and somewhat distressing because of the amount of energy and the team that we've had to pull around us to pull all this together, with at least 3 airfields in the district council's domain, why there isn't some zoning rules around airfields, because at the moment, under the resource consent, we are invisible to our neighbours and we're invisible to anyone else that wants to come into this area. Now, the mere fact that we are there will not change the outcome of our local community's disquiet with general aviation and the letters that you received. And I'd just like to talk to that just briefly around the airspace that sits over the top of Mercer. And we have got some diagrams that we sent out this morning, which if they're able to be brought up, I'd just like to give you a bit of an overview so that you understand the context from which the neighbours disquiet has come, but also how we operate and how we mitigate some of these issues.
Fletcher, this is one of the files I sent to you.
Was this out of the presentation or the aerial zone maps?
The aerial zone maps.
All right, I'll bring that up.
Thank you. So you'll notice that there's a bunch of magenta lines around Auckland, actually. And Auckland sits in the centre of this, where it has an oddly shaped space. But this airspace is, when you look at it on a map, looks like an upside down birthday cake. So it starts at Auckland International, which is right in the middle, and from the surface to 1,000 feet. And then the next section is, to 1,500 feet. The next section is from 1,500 feet to 2,500 feet. And then the section that is overhead Mercer is from 2,500 feet upwards to 4,500 feet. And then the next one that's over, say, the Miranda NDB, I think is from 3,500. Oh no, actually no, that must be 4,500 feet up to 6,500 feet. And the reason for this airspace is to enable aircraft, particularly like our international and regional aircraft that are flying IFR, to make a safe approach, descending approach to land at Auckland International. Now, if you bring up the other chart, which is more detailed, thank you. You'll notice that that Mercer is just to the south of there. There you go, right there. And so there's some pale blue outlines around. Yep, stop there. pale blue lines. Okay, those pale blue lines inside the magenta lines are known as general aviation airspace. So there's two there. There's one that sits over towards Ardmore, which is called G276 Vanilla. And that's been designed for glider aircraft. Then there's one over the area, well, that surrounds the area that Mercer Airfield is in, and it's G275 Ardmore. And it goes from 2,500 to 4,500 feet. Now, Ardmore is almost in line with Auckland International Airport. So it's impossible for them to do any training whatsoever, and it's the largest training airfield in New Zealand. It's impossible for them to do any training in that sphere north of them. So they have to come south. All of the pale coloured areas on that map is high terrain. So in order to be able to do manoeuvres safely and clear of the ground, aircraft must come south to do their training. So that whole area in pale blue around and covering Mercer is known as the training area for Ardmore, but for any general aviation activity. Mercer then sits inside some dotted lines, some dots, and you'll see ducks, and you'll see little airplanes, and you'll see parachute, and you'll see blasting. Remote control. There's a remote control there. That's a mandatory broadcast zone, and the reason it's mandatory is to ensure that anyone that's using that area talks to everybody else in that area, so that we're all aware of where the traffic is and we don't have a mid-air collision. Now, because we're in a rural area, airplanes of any description, whether that's a helicopter or a paraglider or a jet airplane, can operate all day, every day, at 500 feet above the ground, just regardless of whether Mercer Airfield was there at all. I took the liberty of asking, so we record our as part of our resource consent, we're required to record the number of movements at the airfield. And the way that we do that is by recording every radio call that is made in the area. In the month of April, there were 6,129 radio calls made on our frequency in that area. Of those, only 525 were specifically for a movement at Mercer Airfield. So it's less than 10%. So you can imagine, therefore, that the bulk of the issues that our neighbours have are not coming from our airfield. They're actually coming from all of the other activity that is legally entitled to fly down to low level over that area all day, every day, continuously, if they wish to do so. And while we have not had any formal complaints about under our resource consent about activity at Mercer, we have indeed, I have fielded calls of complaints around noise in the area. And in every single case, I respond by either contacting Ardmore to advise them that we've had the complaint. I also use the opportunity to try and educate our neighbours that this is a training area and that aircraft are entitled to be able to operate this, just regardless of the fact that our airfield is there at all. And I say to, and I give the caller the opportunity to contact civil aviation and make formal complaint if they believe that a civil aviation rule has been broken. Now, one of
Ms.
the—
Bond, I think we've made the point that there's an existing Ardmore issue that's sort of dominates. I'm not putting words in your mouth. I don't think you need to elaborate on this point anymore. We understand the point that you're making very clearly.
Well, I just wanted to say that the other side of, as well as the district council encouraging us to go down this track to try and create a zone, the council also have encouraged us in the area for economic development. And it was the council that brought one of our tenants to us, who and we are trying to grow economic development in our district, and we feel very passionate about aviation. We also are involved in providing accommodation throughout the district. So while we provide accommodation backpackers on site, we also provide motel accommodation in Mercer Township. We provide a motorhome park accommodation both in Mercer Township and also in Tuakau down by the river. And we have the only 4.5-star hotel anywhere between Auckland and Hamilton. We're really passionate about what we do. Most of those were either didn't exist or were in exceedingly rundown condition when we picked them up. We have created huge numbers of jobs as a consequence of the work that we've undertaken to create all of our properties at a really high standard. And just, I guess, I'm not sure that it's relevant, but just so that you understand our passion for aviation, we've recently acquired the New Zealand's only significant aircraft manufacturer, the assets of that, of Pacific Aerospace here in Hamilton. And we want to resurrect that and again have an asset that is both locally and domestically and internationally we can be proud of. So at Mercer Airfield, we are trying to create work. We are working with the school, with local schools, our local primary schools. We had a schools day. They brought every single child from the school. So the whole schools came out to participate in an aviation day at our airfield. We participate with our residents associations, and so we were really distressed by the letter from our two neighbours regarding this, particularly as we had no opportunity to deal with the issues that they had raised, but we're more than happy to get together with them. And as I said to both our community committee and to the people that I've spoken directly to on the telephone, it really is a matter of education. And what we're trying to do here is be seen and be visual so people do know we're here. And a resource consent doesn't do that for us. Thank you.
Very good. Thank you very much, Ms. Bond. As I indicated earlier, let's press on with the team's presentation, and then we'll come back and see what questions we have.
So I was going to ask Mr. Park, David Park, to speak next. He's somewhere there on Zoom in another location from all of us. What I thought would be helpful is just to ask him very briefly to explain the OLS and its importance and leave it at that. So
I think he can do that quite briefly, and I only say that because we've heard very similar evidence about the purpose of the OLS presented by Mr. Park at Te Kowhai. So he should focus on the site-specific issues rather than giving us a OLS 101 conversation.
Yeah, okay, it's helpful. So as I perceived it, the site-specific issue here is the extent of the OLS in terms of its potential impact on immediately adjoining properties. In other words, how high is it? Perhaps I could just ask them to speak to that briefly. Sue, would that be helpful?
Yes, that would be helpful. Thank you.
Fletcher,
Yes,
bring up the other presentation, please.
Yeah. Yes, good afternoon, Commissioner and panel. Yes, I will keep this brief. I did just want to show, though, very briefly, a picture of the Catalina aircraft, because I'll mention that it's relevant to the context of the OLS, and the panel may not be familiar with it, so I'd just like to show it. I think it's on slide 5 of that. Yeah, that's it. Now this, as Dee has explained, is a very historic aircraft. It's actually a very large aircraft. The wingspan of this aircraft is about the same as an Air New Zealand Bombardier Q300 seating 50 people. So this is a big aircraft, and it's in that sense it's unusual in terms of your average a smaller aerodrome in New Zealand to have an aircraft of this size operating, but that only adds to the necessity to have adequate flight path protection for it. And the OLS, which other consultants before me adopted or recommended, and I agreed with, for Mercer, is specifically to accommodate an aircraft of this size. The extent of the OLS, if you could just put up slide 13 of that pack. This shows the extent of the OLS around the actual airfield itself. Yeah, slide 13, that's it. And it also identifies the different portions of the OLS, which the panel may be familiar with from my presentation at Te Kauai. But the runway is right in the middle, more or less east-west. And off each end of the runway, we have the takeoff and approach obstacle limitation surfaces. They go out 3,000 meters as necessitated under CAA standards for an aircraft of the size of the Catalina. Off each side of the runway, sloping upwards and outwards from the edges of the runway, are what we call the transitional surfaces. These are intended to provide clearance for an aircraft that has to abort its landing at a very low level and pass over the airfield, or to one side of the runway or the other. So it provides protection for those aircraft. And those surfaces slope from ground level at the edges of the runway strip up to 45 meters above the airfield at each edge of the surface. Then around that group of surfaces, we've got this oval shaped surface called the inner horizontal surface, which goes up to about 45 meters above the aerodrome. And then beyond that, again, we've got a conical surface which slopes upwards to reach a final height of 150 meters above the aerodrome at about 5 kilometers from the extent of the ends and edges of the runway. So that's the complete package of surfaces. They're not dissimilar to what was there at Te Kauai, but they do extend a little further because of the size of the Catalina. In terms of the impact of those obstacle limitation surfaces on surrounding residents, which is obviously a very site-specific thing, I have taken a look at that, and that's described in my rebuttal evidence. And if you could just look at slide 14, which is the next one in that visual pack, I'll just very briefly explain my methodology for doing this. So this shows the western takeoff and approach obstacle limitation surface superimposed on a Google Earth image to indicate what's on the ground actually beneath the obstacle limitation surface at various points. Now I've identified by some numbers A, B, C, D, E, etc. on there particular features on the ground, and in my evidence I describe what those features are and how they could possibly be impacted by the obstacle limitation surface above them. Now the features on the ground that I'm referring to are either trees or buildings. And in the case of buildings, or residential buildings, I guess specifically, there's actually very few. There's one that I've identified as A, which is on that slide is just by that 27-meter line there, which represents the height of the obstacle limitation surface above the end of the runway at that particular, above the Motoriki datum at that particular point. And the Motoriki datum, as I understand it, is very close to mean sea level. and I understand that also there's a building, a dwelling underneath there, which won't be affected because the OLS goes above it, but potentially if the owner of the dwelling wanted to increase the height, it's possible there could be an infringement, although I would doubt it. And the reason that I'm expressing a little uncertainty is we don't know the exact height of every point on the ground beneath the obstacle limitation surface. We're having to estimate this from various topographical sources. Now, I understand that particular dwelling is owned by parties related to the airport anyway. And the only other dwelling at that end is a group of dwellings or buildings. It's not possible to determine exactly what they are from Google Earth, that are labelled C and D. And the obstacle limitation surface at that point is quite high, even though the ground is actually sloping up in that area. The clearance of the top of the between the ground and the buildings is of the order of 30 metres in that area, 20 to 30 metres. So any building is normally there's a height restriction of around 15 metres, I think, in the rural zone, give or take a metre or two. So those buildings wouldn't be affected, and where they are at the moment. There's a number of trees, shelter belts. I think you can see those on the northern side, excuse me, of the white OLS lines on that side. I've labelled them LMNOPQ. Now, we don't know the heights of those trees, but judging from the height of the terrain that they're on, some of those trees could infringe the proposed OLS. Now, my understanding is that trees do have existing use rights, so it would be a matter then of the aerodrome owner negotiating with those owners to, if those trees did infringe through the obstacle limitation surface, to see what could be done about that. Switching to the other end of the runway, which is on slide 15. That's the next one. Thank you. There's actually no dwellings that I could, or other buildings that I could see that lie underneath those approach and transitional surfaces there. But there are a number of shelter belts or hedgerows, which I've identified in there, and I discuss each one of those in terms of its likely height and how it would be impacted by the obstacle limitation surface. And again, some of them will almost certainly penetrate, others won't. Those that do would, as I understand it, have existing use rights, and it would be a matter then of some negotiation between the airport owner and the landowner over those. So actually, in terms of impact of the obstacle limitation surface, in my view, it's actually pretty benign compared to a number of other airfields and airports that I've dealt with. And particularly in the case of dwellings, there's actually really only the 2 or possibly 3 groups of buildings that I've mentioned, which lie underneath the OLS, but none of those, as far as I could see, would be affected. Where there could be an impact is if a property owner right off the end of the runway decided that they wanted to put a dwelling underneath the flight path in that location. However, those aren't existing dwellings. There appears to be nothing in those areas from Google Earth at this stage. So I think that really covers all that I wanted to say.
Mm-hmm. All right, very good. Thank you, Mr. Park.
The next one I wanted to just bring forward is Reese Hegley acoustics. I'd like to ask him to speak to you briefly about 3 particular things that have come up this morning. One is a comparison of the resource consent versus the district plan noise contours, and he's prepared a diagram with some visuals. The second is Mr. Hegley is proposing for clarity a definition of ex-military jets, which are excluded under the zone provisions. And the third thing I want to ask him to just speak to you about is a table that he's prepared of other airports, which I mentioned in my opening. So if you don't mind, I'll just ask him to speak to those 3 topics. Would that be helpful?
Yeah, that's fine. Thank you. Welcome, Mr. Hegley. Welcome, Mr. Hegley.
Thank you. Good morning, all. So to answer the first question, the resource consent, the current resource consent conditions and the proposal, they share similarities. They're quite similar. In both cases, we're proposing a 65 contour and a 55 contour for the aircraft activities to comply with.
So this, sorry, feature this, Mr. Eagley is referring to a contour diagram, which is in the package of visuals towards the back.
Keep going, please.
See that?
No, that's a bit, yes. So,
that's it.
Could you make that a little bigger, please, Mr. Bell? Even a bit bigger again.
So this is,
you make it one more up. That's okay. We can't quite see the end of it, but that's okay. Thank you.
so what you're seeing here, the resource consent contours overlaid with the current proposed contours. If you start close to the airport, the two red lines there, two red contours, the resource consent 65, correct those lines, whereas the orange line outside that is the currently proposed 65 contour. Then if you move out to the yellow lines, the two yellow lines, those are the resource consent 55 contour, and the blue line is the proposed 55 contour. Both are based on 100 aircraft movements a day. The reason the proposed ones are large is because there's a slightly different mix of aircraft, which has a number of effects on the contours, but essentially they end up a little larger. If you're looking at the yellow contours compared to the blue contour, which is the resource consent compared to the proposed 55 contour, there's obviously an increase and it varies around the perimeter of the contour, but by and large it's 2 to 3 decibels, which 2 decibels you described as you wouldn't notice the difference. 3 would be the smallest difference. And to put that in context, if I was varying my volume now, plus or minus 2 decibels, you'd probably notice the change in my voice. These contours represent a 3-month average noise level. And so you're getting what I call quite a small change if you were to observe it for 3 continuous months for either case. So it is, I would consider it's an increase, that's a small increase. Any questions on that before I go on?
No, you carry on, thanks.
Now, from here, the resource consent in the current proposal deviates somewhat, and it's how to deal with the land use around the airport. Currently, the resource consent says, while the airport might be complying with their contours, if there's a problem, they've got to adopt section 16 and sort it out somehow, which is rather vague. But given it was resource consent at the time, it was the best we could do. And now we're going for a plan change. We have the ability to adopt what I consider a lot more sensible land use controls. And that uses the 6805, the New Zealand standard, its approach of putting limitations or conditions, I guess, on any future houses that will develop inside the airline's contours. And in my view, it's a really sensible approach. It gives everybody the knowledge. It literally draws a line on a map, a line in the sand, and everybody in the area, the airport, and any future neighbours all know where we stand. There's no discussion on this. It's a well-known effect, it's planned for, and it's dealt with at this point rather than at some point in the future. I was going to move on to the second of Mr. Dawson's questions, which is the definition of EMJ, the ex-military jet, where the proposal is to fly jet movements into the airport for servicing. And we originally had in condition 29.2.12 that those were to exclude ex-military jets. And Ms. Bond pointed out that almost all jets in some way, shape or form could be described as an ex-military jet, either being used by the military or developed specifically for the military, which left us in a bit of an issue, but there is no definition of an EMJ anywhere. So I would propose to add condition 29.12 words to the effect that ex-military jets shall be defined as those that entered into production before 1955. That will exclude the likes of the Vampire, which are the real warbirds jets, which is, it's a well-known loud jet, but it will include more of the style of jet that the field is looking to service, which is in line with my thinking, it was conventional small style jet. The third of Mr. Dawson's questions was, how unusual is this, the adoption of these air noise boundaries as the surrounding land use controls proposed by NZ 6805. And an answer to that, possibly,
It's in there, yeah.
yes, what must be one of the last, it's a table towards the end of the presentation. You flip through the slides, please. You keep going. And again.
That's as far as it goes, sorry.
Sorry, please, can you go back? It might be sort of jammed in the middle there somewhere. I'm going to send it to him.
Oh, has he not got it?
Here it is.
Yes, brilliant. So first thing I'd say is 6805 was it's a 1992 edition that's been around for 30 years, and to my knowledge is used extensively. And so what we did was just to have a look around in the area around the Waikato, what other airfields do. The first place I went to was the TCDC, and they've identified 4 airfields there. Coromandel, Pauanui, Thames, Mutianga. Now they've considered noise from each, noise to the neighbours in each case. But Coromandel or Pauanui, the conclusion is they're very small airfields without really any ability to grow. So they don't consider there to be a problem there. Thames, they consider certainly has enough movement to resolve the problem, but it's quite exceptional in that it's surrounded by water on one side, all other sides by stormwater ponds, a large recreation reserve, and the like. So there's no potential for residential close to the airport. So there is actually relatively no problem, there's no controls. Mutianga, they certainly consider an issue there, and that's dealt with in the 6805 approach. I went to Auckland, and I left out Auckland International Airport because it's just such a different scale of what we're talking about now, but it certainly has a 6805 style approach and well developed from. Ardmore certainly does, Kaipara Flats does, North Shore, which is Dairy Flat, certainly does, and Whenuapai does. In Auckland, there's also the Gulf Islands District Plan. There's 2 airfields I could find within that. They're both on Great Barrier, Okiwi and Claris. Small airfields, but they certainly have a 6805 approach. The far north, Kaitaia, Kirikiri, Kaikoui, all have 6805 approach. Hastings has Bridge Power, which does as well. And the only one that I looked at and couldn't find anything was Tokoroa. But I've no idea that's actually a very, very small district plan. And that concludes the points I would like to make. Thank you.
Thank you, Mr. Higley.
Sir, I've got the traffic engineer who did the traffic engineering impact assessment that was provided to council sitting here with me. I'm just wondering if you've got any questions for him, otherwise I'm going to let him go.
I don't think we need to hear from him because we've seen his report, but I think it would be wise for him to, we've only got Mr. Dawson to run. So if he's able to wait another 10 minutes, which is Mr. Dawson's allotted time, we should be okay as long as that's not a huge inconvenience to him.
Okay, in that case, I'll ask Mr. Dawson number 2 to come forward.
Thank you.
Good afternoon.
Good afternoon, Mr. Dawson.
I'd just like to cover a few brief points, and these were highlighted in my hearings highlight package, which was sent through and you have in front of you.
Yes, thank you.
So just wanted to note a couple of what I think are really important policies in the proposed plan, which point to the proposal that Mercer Airport has in front of you today. One of them is policy 532, talks about recognising and protecting the continued operation of the rural environment as a productive working environment by, and in Roman 3, providing for lawfully established rural activities and protecting them from sensitive land uses. So for me, that's a fairly strong directive. It's then supported by 537, which specifically looks at reverse sensitivity effects, and it looks at ways to address that is avoid adverse effects outside of the site, and where those effects cannot be avoided, they are mitigated. And that is an approach that the proposed zone addresses. Mitigate the adverse effects of reverse sensitivity through the use of setbacks and the design of subdivision and development. And Mr. Higley alluded to that, that the air noise boundaries and associated rules would have that influence and provide that direction. And then lastly, under D, the scale, intensity, timing and duration of activities are managed to ensure compatibility with the amenity and character of the rural environment. And in my view, that's exactly what the package of rules that we have, objectives, policies and rules that we have put forward through the Mercer Airport Zone seek to achieve. So attached to my summary statement was the highlights package was some proposed objectives, policies and rules. I have amended those to look to address some of the comments made by Ms. Lagarde. And
that's the ones in blue, correct?
Correct. That's correct.
Yes, thank you.
You've heard the importance of the airfield that has economic benefits. It's both regionally significant, but also, as Ms. D commented, they're a strong part of the local community. And the combination of the OLS that Mr. Park referred to and the air noise boundaries that Mr. Higley referred to, importantly, they'll provide certainty. They signal to everyone, those that live there, those that are looking to move into that area, they signal that an airport's there, and there are certain provisions and controls and things to take account of in someone moving into that area in order to protect them and protect the ongoing safe operation of the Mercer Airfield. That's all I wanted to just touch on, Commissioners, but happy to answer any questions.
All right, thank you very much, Mr. Dawson. Let's go around the panel and see what questions we have. Can we start with you, please, Ms. Gibb?
No, nothing from me, thanks.
Mr. Marg?
Likewise, nothing from me, but thank you all very much.
Mr. Fulton?
No, I have no questions, thank you.
Mr. Cooney?
Yeah, just a couple. Mr. Park, if we can put up the OLS diagram.
Yeah, that's slide 13. That showed the extent of the OLS.
That one. Are you seeking a with that? You're seeking what do you call it? The IFR certification.
The OLS is primarily there to address the requirements for the Catalina. However, it does actually cover IFR operation of smaller aircraft as well.
Okay. So if you're seeking the IFR, do you need the north transitional area to be included?
Well, do you mean seeking IFR only?
If you're just seeking IFR only.
IFR only, the transitional surface would have a different shape. That's IFR for smaller aircraft. It wouldn't extend out that far.
Okay. So that, but do you still need that type of protection zone?
For the Catalina, yes, that's correct.
For the Catalina, okay. I think there's two questions here. You need that for the Catalina, but if we just ignore the Catalina, do you still need that north transitional area there to get an IFL certificate?
IFR, it doesn't need to be quite that large.
Okay, but you still need one.
You still need one. Yes, that's correct.
Okay. Yeah, thanks for that. Just on the other question is, if the owner does not wish to negotiate for any trees that do intrude at the moment, the trees stay, don't they?
I'm probably not the best equipped to answer that question. My understanding from case law is that trees do have an existing use right. I think that has some constraints around it. For example, a tree that's not at its full height, I think its existing use right applies at the date the plan change is adopted and not beyond that. Yes, but that's perhaps more of a legal question than a
so just on the assumption that the trees can't be removed,
yes,
you have to then adapt through information on your flight paths and so forth.
Well, there's two potential things that would happen. The tree would have to be notified as a flight path obstruction. The pilot of the aircraft is then bound to take appropriate action to ensure the aircraft can remain above that obstruction. That could, for example, mean that the aircraft can't take off at a weight that it could otherwise take off at. The weight has to be reduced so it has better climb performance. It's probably more of a, well, that's an impact, but on landing, the potential impact I think is a bit more relating to flight safety, and that is that the aerodrome operator may have to displace what we call the landing threshold, which is a point at the end of the runway where the aircraft is supposed to pass over just prior to its wheels touching down. That may have to be displaced inwards to enable the aircraft flight path to clear an obstacle earlier in the approach. Now that can mean that usually does mean that the landing distance available to the aircraft before it gets to the far end of the runway on its landing roll is reduced, and that increases the potential for the aircraft to run off the far end of the runway if things happen in landing that mean the aircraft can't be stopped in the planned distance.
Okay. Yeah. Okay. So thanks for that, Mr. Parker. Mr. Higley, can I ask you just a question? You there, Mr. Higley?
Yes,
yeah. Okay. You can take that off. That off now. Just that diagram you put up, the first one showing the various contours. What were those outer contours? I haven't seen that contour. I don't know whether did you provide it in your rebuttal?
The blue and the orange contour are currently proposed air noise contours, and they're in my evidence, my original evidence, and they're one of the figures in the slideshow.
Yeah, the photo you put up, the contours you put up right at the start of your evidence.
Of my evidence or
today. Yeah.
Yes. Yep. The blue one and the orange one.
Yeah.
Would match what's in my evidence.
Yeah, that one. So what are those outer ones again?
55 decibels.
Yeah. And they were recorded. The differences because of the different aircraft variety. Yes. Is that right?
Correct. They're both for 100 aircraft movements a day. The blue one, the larger one, the currently proposed one, is got slightly more noisier aircraft, so it pushes the contours out a little bit.
Okay.
So the yellow lines are just the 1996 consent, or the 2013. Sorry, 2013 contours that were approved. So just to give you the comparison.
Yeah. So the difference really in the different extensions is due mainly to the different aircraft variety. Is that right?
Yes, solely due to that.
Yeah. Okay. Thanks. Thanks, Mr. Chair.
I've just got 3 questions, and they're also for Mr. Higley. So don't run away, Mr. Higley. I just want to ask you another question about this particular map, because, and as I understand it, the orange and light blue lines what is proposed under this rezoning proposal.
Correct.
Whereas the yellow and red lines relate to the existing resource consent.
Correct.
I also understand, if we just focus on the yellow lines for a minute, that they, well, I just want to check. I'm not sure that we're comparing apples with apples, are we, when we're comparing the yellow line and the light blue line, for example? Because doesn't the light blue line apply at ground level? And there's a different means of calculating those two 55 dB contours based on the height of the aircraft when the measurement is being taken?
The two lines, the yellow and the blue, have been calculated identical ways. They represent exactly the same situations. They're both calculated. Yes, the aircraft noise level resulting on the ground from the aircraft activities in the air.
But don't the yellow lines relate to different heights of aircraft above the ground? That's why there's two yellow lines, not one.
Sorry, no. All right. There is two yellow lines. If you look at the runway,
yes,
the solid white line, that's the existing runway.
Yes.
And off to the right, I've drawn the outline in white of the extension. There's an extension proposed.
Yes, I understand that.
Now, if you essentially think of a departing aircraft to the west, under the current proposal, under the current situation, they'll start on the white, and that pushes the contours out to a certain distance off the left-hand end of the runway. If you pull the starter roll back to the proposed end, that same contour moves back in relation to the length you move the runway to start to roll. So there are two situations. One of those yellow lines is for the current length of runway, 750 metres.
Yes.
The yellow line is if they were to extend
it's a runway, sorry, that's the thing that I was confused. That's a runway length, not a height above ground noise contour or aircraft position. Sorry, that's clarified. I understand now, thank you.
And I didn't repeat the same dual contour for the proposed because it looks confusing.
No, I now understand. It's a runway length metric, not a contour based on a height above ground level or height above motoriki datum, which is what I interpreted it as being. Right, that was my misunderstanding. Can I just ask you two more questions? The first one is, you've made mention of I think it's NZS 6805 as being the noise standard, and you've referred to that in paragraphs 8 onwards of your primary statement. Yes. In that discussion, you mentioned that the noise contours that, or the noise contours that you've developed are based on a 3-monthly average. Does NZS 6805 specify that as a standard, or is that the standard that you've adopted here? It's not clear from your evidence.
Sorry, NZS 605 recommends 3 months.
Okay, thank you. And if we take, for example, a 65 dBA or let's say a 55 dBA 3-monthly average, if we use the more normal noise metrics, what used to be, things like L10, which I now think now understand have a different metric. How does 55 dB measured as a 3-monthly average compare with, for example, an L10
that's okay.
Measured in the conventional way?
Just
that's 3-month average is an awfully long time, and I imagine smooths out a whole lot of zeros. That's the point of my question, if not, even if I've got it technically incorrect.
The point of the 3-month average is that for instance, the wind was blowing from the southeast the whole time. Say you went to measure for a single day, which is not a conventional way we do things based on a daily average. You measure for a single day, all the aircraft might be taking off in the opposite direction. There'd be no noise from the airport.
Well, yeah, let's assume the opposite, and let's assume they were
in that case, yes, you'd be measuring higher levels, and you'd be saying, well, it wouldn't be a.
But how much higher would they be? That's what I'm trying to understand.
Yeah.
What could an L10 number be?
Well, that again, it depends on the aircraft that's using it and the track it's taking. And I think probably a good way to answer your question is on one of the slides I presented. I've used the contours and the jet going over. So we could flick. It's an earlier slide than this one. Earlier, please.
No, about the other way.
Oh, sorry,
Later.
50. So there. So that's the reason I didn't want to include the jet in the base contours was because it was a single movement, and I think it would have got lost in all the other what's going on. So I wanted to show it individually, and that probably answers your question quite clearly. In that the red line, what looks like a white line to me there is actually the 55 contour that equates to the blue line before.
Yes.
If there is a single jet movement, those are departures. Of the red line is the departures from 3 tracks. So the jet is the loudest aircraft using the airfield, and the single movement from a jet extends a wee way beyond the current 55 contour. Now that jet movement, what I've done there, rather than using a 3-month average, which would horribly distort it, I've used a 15-minute average, which is much more conventional for general environmental sound. So I think if I understand your question, you're saying if a typical aircraft movement from the airfield were to leave, a Cessna, a small, small general aviation aircraft to leave from the airfield, the individual noise contour would be significantly smaller than those red lines, which represent a jet, which is one of the loudest activities. So an individual movement would be likely inside the white looking line, my blue 55 contour there.
I think that sort of answers it, but I'm not sure that it does. So I'll ask it a slightly different way. Let's assume that you had compliance with NZS 6805 based on a 3-month average measurement. In other words, and as I understand that, that means you'd be somewhere on that white line.
Yes.
If you then had those same aircraft running such that on a typical day when things were taking off in the same direction, how would the L10 value on a day compare to the L10 value based on a 3-month average?
It should be similar. They're very similar.
How does that work though? Because if you're taking a 15-minute average and there's no planes flying, there's a lot of silence all the time. I guess my point is, how much does this 3-month averaging smooth out everything so it doesn't really matter how noisy it is, you're always going to achieve the standard? That's a very crude way of expressing the question.
I understand, yes, but by averaging the noise out over time, it's an average, exactly. The reason it's done like that, though, is people respond to the average noise. If you said, is the airport noisy or quiet, you would be asking the question, on average, is it noisy or quiet? People wouldn't say, one plane flew over yesterday, it was noisy. They'd be saying, in general, it's a noisy airport, it's a quiet airport.
No, but if the airport's proposing to expand and have a different noise profile,
yes,
it's relevant to say, actually, I didn't hear much at all before, and now it's quite noisy and it's annoying me. That's what I'm trying to understand. And I'm not trying to be cute. I'm just trying to understand how much smoothing of the data does this 3-month average give you, such that it really wouldn't matter what you did. You'd comply with the standard, because it's designed to facilitate airports, not to protect amenity necessarily.
No, the standard is written to do both. It's meant to be a middle ground. It's meant to give airports a ability to operate with controls that are appropriate for residential amenity. So it does try to split the difference.
Let me try and express this a different way. If this wasn't an airport and it was a typical rural activity, we wouldn't have a 3-month average. We'd have L10 in the old language. I know it's got a new terminology, but we'll call it a L10. That would be 55 during the day and 45 at night, or something similar to that.
Yes.
The noise that would be experienced as a result of compliance with these contours that you've proposed would be how much different from what a rural land use would produce?
They would be quite similar, because although it's a 3-month average, it's averaged down to a single day. So it's meant to represent a busy single day at the airport.
All right. Okay. I think I understand that now. Thank you very much. Can I also just ask you one final question? And that is, the contours that are on this diagram and the other diagrams compare the noise allowed by the current consent versus the noise that's proposed under the new zoning provisions. How do either of those compare with the existing noise environment, assuming it's been measured? Or has it been measured? And has it been measured?
No, it's not being measured. Yeah, if you can look at the contours, they do cover quite an area, quite a large area. So no, we haven't been through that process.
So can I just make a comment on that?
Yes, please do.
The existing environment, quote unquote, is with the consented noise contour in place.
Yeah, I'm not asking a legal question about it. I'm just trying to understand what the level currently being experienced is. I fully appreciate the fact that under the current consent, it may be able to be more noisy than currently, and if the consent is being exercised fully. I'm just trying to understand, as part of the whole equation, how noisy that environment is currently after some 8 years of consent existence. But I'm not trying to get to that legal point, Mr. Dawson. I'm just trying to understand how noisy that environment is at the moment.
Yeah, when I suggest it varies quite a lot from being close to the road to being up in the hills. Probably my actual response would be that the 55 limit is a reasonable residential amenity. You know, it's a good level of noise for protection of residential use.
Yeah, but that's not my question. My question would be, what would that white line look like if you were basing it on measured noise, as opposed to noise that would happen if the airport was running full tilt as per the current consent? Would it shrink by much?
When you say measured noise, are you talking the ambient still, or you're talking?
I'm talking about if you went out there and sat with your noise meter for however long you need to do it and measured the existing noise environment around that airport, how different would it be from the white line that's shown as being the, if you like, the compliance limit for the current consent?
It would vary, I think, across the entire area covered by the white line. As I say, close to the road, you'll be getting, I don't know the traffic flows, but you could be getting higher levels. Up in the hills there to the southeast, I'm sure you'll be getting lower levels.
Right.
I imagine the ambience in a rural environment during the daytime are going to be in the 40s, 50s somewhere.
Okay, all right, thank you very much. I don't have any further questions. Thank you, Mr. Higley.
Mr. Chair, just one question on Mr. Higley. Mr. Higley, just looking at those the jet contours that you've got there, and they extend out past the 55 contour. Just from a noise perspective, jets are annoying to a neighbourhood.
No, I think beauty in the eye of the beholder.
What's that?
Beauty is in the eye of the beholder, I think. Some people, and I've always been surprised at different sources of noise. Some people love it, some people hate it. And that's true of any source.
Is there any background studies on the effects of noise, from a jet on stock horses and things like that?
I know the US military have done limited amount of study on this, on horses. generally, it's certainly close to the source. There's problems, but most stop habituate very easily to this. And I guess in response, every airfield, or most airfields, are a rural environment, and often farmed by the airport owners themselves.
Yeah.
I don't see that as a big issue.
Okay. Okay. Thanks.
All right, thank you very much, Mr. Higley and team. I think that's the end of our questions. Is there anything you need to address us on in closing, Mr. Dawson?
I'd just like to leave you with one final thought, if I may, and that is if you could pick up your highlighter and go to page 18 of my legal submissions. I've quoted there an extract from the Windstone aggregates case. And
what paragraph? I can put it on the screen. What paragraph number? Sorry, 18.
It's paragraph 65, page 18 of my
page 18.
We can perhaps blow it up a little bit. And there's a sentence there, 1, 2, 3 lines down from the top of page 18. And it begins with, in the event of adverse effects escaping from the site after the imposition of reasonable controls, then restrictions constraining adjacent landowners should be implemented. That's the sentence I'd like you to highlight, because to me, that's what this is all about. It's not about whether the existing resource consent we hold is adequate. It's about what's an appropriate zoning for the next 10 years on this property. And the answer or the issue that confronts us is that very sentence. I'd like to leave you with that thought, perhaps.
Right.
And I'd like to thank you all for your time. I know that we've had a lot longer than we may have expected, and I'm grateful to you all for your time and indulgence and having taken the time to prepare so thoroughly beforehand. It's much appreciated.
Not bad, these Zoom hearings, are they?
I'm not sure if I go that far. They do. I will admit, though, they do have some advantages. Not too bad.
We'll take that as being damned by faint praise.
That's probably a good way to look at it.
Yeah. Very good.
All right. Thank you, everybody. We'll now adjourn. If the panel wouldn't mind just waiting for a moment, please.
Thank you.